Either then.
My lord,
Yes.
PIL 28 of 23 was listed on fixed for hearing on 28/8, but somehow it has not made it to the list, my lord. This is about notification by Lake Protection Committee. They have to file the compliance of my lord's orders.
Uh-huh.
A date
Your
may be
date was given.
Yes,
Find
yes.
out, Mr. Why it is not listed.
Much.
We'll find out. It will be listed
Any date.
at the earliest. You take Mr. Registrar Judicial, please take.
Apply.
Yes. Huh? Yeah, that's over, right? No. It's not possible. Move an application for urgent hearing. Yes. There are guidelines for applying the copy. Copy is not furnished to you at your residence, right? Or at the airport. Apply this thing. If you don't get it, then say certified copy. There is a Mr. Counsel. There is a Mr. Counsel.
No.
Listen to us.
Are you aware we have passed the order saying that all interim orders will be made available between 1 to 3 days? We have released it yesterday already.
Mr. Praveen Kumar has complimented us in open court. Show him.
Association also.
That every time blaming the court, right? Like supposing the vacating stay would have been dismissed, you would have all the smiles. Hey, this is the game. Mr. 1 minute. Yes.
Mr. Krishna, there is no point. We have already said it is more than a week. If you are not aware, we can't help.
Yes.
Previous admissions will not. He is studied up to 10th class here in Hyderabad only, but his intermediate pathway exam is from Rajasthan. So,
Do you supply a copy to Mr. Supply a copy.
my lordship.
Supply a copy. It's listed in list. No, he is mentioning.
Last day for
Today. We will get it today.
my lordship.
Right. My case is also neat.
No, neat which covered by the order.
Covered by lordship's order. Look.
Rule 3.3.
Yes,
Rule
yes,
3.3.
yes.
Give rule 3.3. Everybody gave today. And please supply a copy to Mr. Prabhakar. Rule 3.3. We will do it. Yes. This is rule 3.3, Mr. Correct? Whosoever given the mention memos, it's the rule 3.3.
Covered by the batch order. If it is only covered by batch order, please give the slip.
My 470 April 470 of 2030 plus the San
470.
of 2030
Ah.
plus the third million and reserved subsequent.
I have never done it my entire life, and it's not a case where I have reserved and not delivered the judgment. Forget about it. Incorrect statement. Yes.
Not the San.
No pendency even as on today. Yes.
Your Honor,
Next case.
Your Honor, we filed PIL in 2021.
What is you want final hearing, right?
Your Honor, the
File an application for urgent hearing. Clearly, final hearing of PIL. Please file application by mention memos. We are telling everyone that it is not granted.
Your Honor,
Yes,
the
yes.
respondent was issued notice to file a reply, and they have not filed the reply.
So,
till date.
no, it will not be listed just to say that list after 4 weeks. Not madam. Don't like. We have better things to do than granting time to this thing. Yes.
My lord, bill number 15/23, so it was actually supposed to listed on 25th August. Bill number 15/2023.
15th August, it can't be listed.
15 number, bill number 15, my lord.
No, number doesn't matter, Mr. What is the urgency?
My lord, actually this Krishna is nearby the Krishna river. If the industry is going to be
No, the pending is, the writ petition is pending since when?
since April 2023, my lord.
23. What has been done in the order? What is the prayer in the writ petition?
My lord, not to grant environment clearance, my lord.
So environment clearance has been granted?
No, madam, but it was proposed to.
No, so what is the urgency like? Why it should be heard today? You tell us.
Not today, my lord. Actually, there is no next date. Kindly allot a next date for each.
No, it will be, next date will be assigned. We have introduced a system, Mr. We are announcing, we are making it known everything, right? That the auto dating system is in place. In cases where no dates are given, the system generates a date.
May I please?
You will get a date. And if you want final hearing, please, every day 10 times we have to tell, if you want final hearing, please move an application for urgent. We will consider.
May I please?
It's not that, yes,
Your Lordship, it is a judicial service matter, Your Lordship. It has to be listed today, but it was not listed, Your Lordship.
listed today. What is happening judicial service?
Judicial compulsory retirement at the age of 50 years it was.
Ah,
But it has to be listed today, Your Lordship. It was not listed.
see, Mr. Why it is not listed? We will find out. Yes.
May Your Lordship.
Date is given, why it is not listed, we'll find out. Yes.
May Your Lordship.
Sir, good morning, sir. In the
Okay,
person,
1
sir.
minute, 1 minute.
Your Lordship, writ appeal 761 of 2023 listed for first time on 4th August. And because of some omission of material papers, I requested for a memo. I filed on the same day, My Lordship, but next time the date was not, unfortunately not listed. The first time fresh matter, My Lordship, because of that day. Some date, fresh matter, Your Lordship, writ appeal.
We give it, see, Mr. Registrar.
Much obliged,
Sir.
Lordship.
Yes. Ah,
Application number 7091, my lord, pertaining
ah,
7091 of 2023. Date petition pertains to promotions and transfer of teachers, my lord, it is detached from the batch. And, my lord, Rashid has vacated the state.
ah.
And, my lord,
Not vacated the stay, modified the stay. And we don't owe an explanation for the order asked by us to you, which is 136. Ah,
my lord, and
we don't owe any explanation. Ah,
my lord, reservations, promotions, my lord. If respondents go ahead with the.
ah. Hey, what do you want, Mr.?
Maybe here, my lord, maybe.
Final hearing, we don't grant every day 10 times we are telling, if a petition is admitted, you want final hearing, please move an application for urgent hearing. The rule is for everybody same. It cannot be for different. For you. Correct. No, you decide, very simple, right? We are human beings. We are doing our best, right? You decide every case. When you become a judge, every case we will stand there and say that item number 1 decide finally, 2 decide finally, then order supply copy today itself, then you will realize. File an application for urgent hearing. Nothing has happened. Nobody is being hanged by neck, right? It's not that he will leave, depart the world and cannot come back. It's not a situation like this. No death sentence. If this was a case of a death sentence, we would have stayed awake and heard everything. Yes.
My Lordship.
Sir,
Ah,
good morning, sir.
yes.
My Lordship.
Sir,
No, there is no good morning. Yes.
sir,
What?
in the person, Tumalapalli
You
Rama.
contact registrar judicial. What do you want?
సార్ నెట్ లో చూస్తే కేసు నెంబర్ ఉంది సార్, ఈ రోజు చూస్తే లిస్ట్ లో లేదు సార్.
But today it is not listed.
You meet Mr. Reddy.
అమౌంట్
Registrar.
వచ్చారు ఒక డిజబిలిటీ పర్సన్ సార్, ఈ సోషల్ వర్కర్ సార్.
My Lordship. My Lordship.
Ah.
WP number double
Yes.
two.
Call.
WP number. My Lordship, please.
Ah.
WP number 22.
No, so you, we are making a statement, no case has been heard by us and not this judgment delivered.
Actually, the matter was
Not is
posted.
done.
The matter was posted on 28 August for hearing, Your Lordship. But unfortunately, it was not listed. The matter, sir.
Absolutely. You find out why it is not listed. It can't be that a court given date is not listed. It can't be, Mr. Reddy, look into it. He will look into it. And if the statement is found to be false, then you will be. There is a difference between court giving a date and system giving a date.
The respondent number 2 and 3 are supposed to file their counter and hearing. The
Counter and hearing.
supposed to
Who
file.
will hear? They will file counter, you hear them and pass an order, sign it and give it to them. They will obey it. Yes. Next.
Millard, item 39.
No, that practice has been stopped, mister. No, this thing mentioning because other side is not there. We have received complaints that in their absence of the council, people have got an adjournment. Wait, if you want to go. We will decide it. Whenever order, whatever order has to be passed, we will pass. Yes. Don't stay there if you have to go somewhere.
There
Yes.
is no council.
Tell. Yes.
Please, Your Lordship.
Ah. How is the very person himself is removing the illegal custody? You said that you yourself are ready and willing to remove the illegal construction. Then where is the question of being agreed by the order?
My lord, it is so happened, my lord, the order passed by the last single judge is, but without hearing me,
No,
it
that's
was
correct.
not served.
No, that's correct without hearing you, but it is your case that I am myself removing the illegal construction.
But it was already.
Then there is no
part
question
of
of being agreed by this order.
a part of the deviation have been removed,
Ah.
but without reference to that, based upon the complaint filed by the fourth respondent in the repetition, but
You will also be heard. That we will modify the order by saying that you will also be heard. Correct?
I have
This
put the
intra-
respondent number.
This is, he will also be heard. How can his construction be removed and he be not heard, Mister?
My lord, already this is second notice, my lord.
Whatever
Yes.
it is,
Whatever it is.
he has to be heard, whatever.
26th round also, then also he has to be heard.
My
In
lord,
this,
bill
this
number 36, my lord.
this intra-court appeal has been filed against an order dated 13th June 2023 passed by learned single judge, by which writ petition preferred by respondent number 1 has been disposed of with the direction to collector and commissioner Medchal Malkajgiri district, the collector Medchal Malkajgiri district and commissioner so and so Pirzadiguda Municipal Corporation to initiate an action. No, it is has been disposed of with the direction to Commissioner Pirzadiguda Municipal Corporation to implement notice dated 14/10/2022 and pass an appropriate order. Learned counsel for the appellant submits that in compliance of the aforesaid notice, part of the construction has been removed by the part of the construction which was not in conformity with the sanctioned plan has already been removed by the appellant. It is submitted that the
Yeah,
23
reinforce.
condonation of delay condoned I is allowed, dispensed with, and then this order with consent heard finally.
May I please your lordships?
Single judge had observed. No, single judge is observed, but yes, we can.
Point of notice is not there, that is right.
But
You also say, including respondent 4.
yes,
May I please your lordship, the present writ appeal is filed against the orders of Honorable Learned Single Judge in WB number 19985 of 2023, my lord, dated 27/7/2023.
you have not been heard.
My lord,
Before passing the order, you have not been heard.
no opportunity was given to me, my lord. Directly, the orders were passed on the date of admission itself, my lordship.
Though you were arrayed as a respondent, you were not heard.
I was arrayed as the respondent number 4, my lordship.
So you were heard.
Not heard, my lord.
It was what we are saying.
Single judge said, my lord,
So what is this thing you will be given notice? This order is in force because this court or learned single judge of this court cannot decide what is unauthorized construction. That has to be determined by an authority. That authority will determine it and will hear you. What is wrong?
There is only one submission, my lord. Page number 14 of the writ order, my lordship.
Ah.
For a moment, page number 14 of writ order.
We have seen it. What is it? Not a.
My lord, whatever the speaking order is there for the demolition, my lordship, the speaking order was released by the official respondents without considering the reply given by the
Speaking order, what has been cancelled?
not cancelled, my lord.
Then,
My lord,
but you did not file any. If you want to challenge a speaking order 47, you file a petition. You are a respondent in this petition. In his petition, the speaking order cannot be set aside.
agreed, my lord, but opportunity should be given to me also, my lord.
Opportunity is given.
Please read the last 4 lines of the order at para 5, page 14.
Where?
Para
This
5,
intra-court appeal is filed against an order dated 27 July 2023 passed by learned single judge by which writ petition preferred by respondent number 1 has been disposed of with the direction to the to district collector as well as Adilabad and municipality Adilabad to next. Dispense with, madam, dispense with, etc. Allowed.
But I picked up your opinion.
Ah,
But in a writ petition challenging the ULC proceedings, the learned single judge decides the title, identity, and possession, and is contrary to the judgment passed by the Honorable Supreme Court, direction passed by the Honorable Supreme Court. Apart from these three, and also an order is granted, which is not even sought. But your lordship may come to page 43. Correct.
madam, the order in writ appeal we had passed. It's not there. The writ appeal order we had passed.
where we said that the
Question of title cannot be gone into and.
Last Thursday, my lord. Last Thursday,
The problem is we don't have the copies of the judgments which we deliver.
I'll place it, lord. To do
When will you place? These people should have it, but not there.
697.
All Mr. PLN. Twenty-eight. Learned senior counsel for the petitioner appellant submits that the learned single judge grossly erred Madam, every day we have to call
Little detailed order.
detailed order from now.
This is, yes, sir.
Also, every day we have to call for next 4 days, 4 judgments we have written every day, PLN will come and deliver. Why you don't have, madam? You are a court master. Yesterday, same thing happened, right? Every day is happening. I'm surprised that you people don't have a copy of the order. And you don't know about it also. That's the best part. You don't know about it also. Learned senior counsel for the appellant submits that the learned single judge erred in deciding the title of the writ petitioners in a writ petition and in erred in granting a relief which
Conferred on any authority for issue of NOC.
Lordship, I come to page 46. The learned judge grants the direction, my lord.
We have seen that page.
no NOC for what selling the property, what?
Correct.
Understand, Mr.
Maybe
Tesh.
for construction. That's what I said.
NOC for construction or what?
NOC for construction, my lord.
Mr. PLN, they don't have the copies of judgments which we have delivered. I wanted copy of WA. It's not there. They don't know which WA. They don't have the copy. So every day we will have to call you at 11 and ask for, because they don't know. Why can't they keep one extra set? I really don't understand. WA, question of title and this.
Some of the important questions which we have rendered, they keep coming.
So like blacklisting yesterday, tender thing cannot be for life. Give, she doesn't know.
It's for construction, my lord. For me, NOC.
Learned senior counsel for the what? Yes, erred in deciding. No, before that you write. Learned senior counsel further submits that the under the Urban Land Ceiling Regulation Act, which has been since repealed, comma, no NOC can be issued. Full stop. In view of aforesaid submission, it is directed, issue notice, etc., accepted, heard on IA 2 of 23. In the meanwhile, operation of the order passed by learned single judge, no order passed by the in view of aforesaid, comma, no, it is in. It is therefore directed that the operation of the order insofar as it contains the direction to issue NOC in favor of writ petitioner shall remain state.
Oblige.
Copy. You also keep make one photocopy and keep it, madam. Give one copy to me also, so that we don't trouble you.
Folder you keep it.
And one copy, take it from this thing. From PLN. Yes, yes.
Apply. Maybe. But petition, appellant is seeking leave to prefer appeal made as the appellant is not non-party to the writ petition.
It's only an IA.
IA,
But you can file, writ is pending, it's an addendum order.
in fact, my lord, writ itself is for consideration of disposal of representation. That IA also has been ordered.
So have you filed an IA seeking implement and vacation of this stay?
No, my lord.
Then-
Let me explain only one aspect, madam. May I invite
No, you tell us, why can't you argue whatever you want to argue before us, before the single judge by impleading and vacation of
But
stay?
in fact, main prayer itself has been granted by the single judge.
So that you can tell him.
Page 35 last message. I will only page 35 last message.
Main prayer is granted, correct? Understood.
Not in the
But we are asking you, why can't you make a submission before the learned single judge instead of coming here in writ appeal?
that has been granted in April 2019 and still the authority page 277 may invite last.
And 1548 delay and all that, you can get away.
But
We will request Mr. Please, senior counsel, please appreciate, we are bound to hear you, but we have to cut short the time. You are senior counsel. That's why we are telling you that you can file an application for impleadment and vacation of stay. We can request the learned single judge to decide it expeditiously. Choice is yours, argue. Yes. It's a delay of 1548 days first, condonation of delay.
But delay, insofar as delay is concerned,
I am not party, so never knew what is happening around the world. Yes.
knowledge party. But
Next. What about merits?
the merits may invite you last.
Main relief is granted by way of an interim order.
In a different IA. I am not challenging that IA merit. Therefore, my
No. So one only answer one question, whether it is which law prohibits you from filing an application for impleadment and seeking vacation of stay?
I leave it.
Which law? So
But my only request merit that some
shall
time,
we say that,
some time limit may be.
yes, shall we say that you state that you will file an application? Learn it.
But
This
my only
intra-court
request-
appeal has been filed against an order dated 25th April 2019, passed by learned single judge, by which an ad interim order has been passed. Paragraph learned counsel for the senior counsel, paragraph learned senior counsel for the appellant after arguing. Leave petition, madam, etc. withdrawn. No orders required. And see, yesterday she had taken dictation. One case we was mentioning vacating state. That order, ask her to are doing it. So as soon as it is done, you keep it before me for reading. It will be flag. Otherwise, it will get signed. I want to read it before you. Council was making a submission. Not today morning itself.
May it please your lordship.
Yes.
It's matter under the provisions of SARFAESI Act, my lords. Petitioner is neither a borrower nor a
Any person.
my lords. I am the auction purchaser, my lord. The third respondent has conducted auction.
No. Mr. The only thing is whether any relief can be granted to you in the absence of challenge to final order dated 16/5/2023 passed by the Debt Recovery Tribunal.
My lords, since the
We are asking question.
yes,
You say yes, it can be granted.
my lords, this honorable court has
No. Mr. That's what I mean.
but this honorable court has been consistently holding that non-mentioning of pendency of litigation is in violation of Rule 86 and 87F. But I'm supported by two division benches judgment of this honorable court, my lord.
No, no, this auction they have conducted, bank has conducted some auction in violation of law and rules,
Yes,
right?
yes, my lord.
What is the forum of challenge?
My lord,
We are,
DRT has already set aside the auction, my lord.
then why have you come here?
My lord, my amount was lying with the,
Is not being defended by the.
but since the auction is in violation of 86 and 87F, let's,
Debt recovery tribunal has set aside the auction.
yes, my lord.
Right? You are sure the bank has not preferred any appeal before debt recovery appellate tribunal. The bank is a chronic litigant. It will never leave you till, if possible, up to International Court of Justice also. It's not possible to take a matter of auction of property to, but we are telling you they will go to Supreme Court, they will file review petition also.
My lord,
Are you sure? Are you in a position to make this statement that order passed by the debt recovery tribunal has not been challenged?
have not received any notice, my lord, from the DRAT, my lord. Since I was also a party before DRT, if any appeal
You
would
will
have,
receive notice. Shortly, we will receive
my lord,
notice.
only now, my lord, now I am not interested, my lord, because but the auction is in violation, is clear in violation of 86 and 87F. This honorable court has been
Counsel for
consistently,
the 1 minute. English.
but may I refer to,
No, no.
my lord,
So
to
then,
the-
Mr., then you are claiming interest at the 25% and 18%, that will be the problem.
my lord, this honorable court has,
Right.
my lord, I am supported by three
That's it.
judgments, my lord.
Fine. Learned counsel for the petitioner submits that in view of, submits that the debt recovery tribunal by an order dated 16.
Matthew Varghese versus M. Amrita Kumar. It's 2014 5 SEC 610.
Which para?
It's the last para.
Whole judgment, right? Starting from first paragraph till last.
Last para, let's deal with interest part.
Issue notice. Issue notice. Yes. Yes. Yes.
Present, your lordship, this is matter questioning GOMS number 26, your lordship. There are batch of matters pending.
This, this calendar, I am unable to see. What GOMS?
GMS number 26, your lordship. There is a batch of cases are pending.
What
You
pending?
got to the same. I'm appearing for respondents. Petitioner, she is.
Petition is admitted for hearing notice.
Blessed, your lordship.
Mr. Rao, you will consider, no? Which page?
Page 22 to 25.
Page 22. Madam, order, same order. Page 22. With consent of the parties, matters heard finally disposed of.
That is for PGM. Malad. Malad, here
Acha, so madam, this only changes NEET UG course. Huh? UG course. Then NEET. What rank you got, Mr. Rank.
And they are ranked 1 lakh 184 3.
1 lakh,
Malad have got 18,420.
18,000. So difficult, Mr. What rank you assign? He is unable to even read.
But regarding category rank is 11 lakhs.
Huh?
11 lakhs 84,384 Malad.
84,300.
84,384 Malad. I'm sorry.
That's why he was unable to read. Or must be feeling shy of this thing that. What? It is not you petitioner, right? 11 lakhs. You must have been a very bright student, we are sure. Huh? Yes, Mr. Counsel. Correct? Management as well as NRI quota. Huh?
Secret.
Mr. Rao, management as well as NRI quota you will consider. This correction, right? With consent. 23, the corrections I have made. Same, disposed of, yes.
Right.
Eight. Yes, madam, quickly.
Consider that.
What is the A category?
Consider A category, you want issue registration for A category.
Con-
Already has submitted a representation to consider.
Yes, Mr.
Yes, your lordship, page number 28 Malad. The
Not
representation.
the presence with consent of the parties matters not finally in this writ petition, comma. The petitioner inter alias seeks direction to the respondents to consider his case for admission to MBBS stroke BDS course for academic session 2020-23-24 under A category within bracket CQ quota. Full stop, paragraph. Learned counsel for the petitioner submits that with regard to his grievance, the petitioner has submitted a representation dated
Malad 23/7/2023 Malad.
23/7/2023 to the university, and the writ petition be disposed of with the direction to the university to consider and decide the aforesaid representation. Mr. Rao, with his usual fairness, submits that the aforesaid representation shall be dealt with by the university within such time limit as may be fixed by this court. Paragraph. In view of aforesaid, taking into account the nature of controversy involved in the petition and in the facts of the case, we will sign it, Mr. the moment it is brought before us. Same thing which
Let GOMS number 72 last.
To suspend the operation of the GOMS number 72 Miller.
70.
Issued
Read page. So interim order is there, madam.
Page 49.
49.
49, 6/9/23.
WP 1.
Right. Madam.
7.
6/9/23 along with WP number 23100/2023. Right. In the beginning, same order. So, Mr. This thing, Rao, there are others also, 10, 11.
Item 10, 11,
Madam, write down. Item 9, 10, 11,
13, 13,
13
to 15, 14, 15,
13 to 15,
18,
then 18,
18,
18,
18,
18,
21, 21 also.
21 also.
21.
21, 24.
24 is different, check A category. 24 is
No,
A category.
so all right. So, madam, you have written all this. Huh?
No, no, I'll just.
Number. Correct.
Yeah.
All right. Yes, madam. Next. Item 12, contract employees.
May please, Your Honor. Lordship, I'm for the counsel for the petitioner, Lordship. I filed this writ petition questioning the action of the second respondent in
What
issuing it.
happened?
Lordship, I'm coming on the third, later on.
We know that you are a contract employee of special magistrate,
Yes,
court
Lordship.
magistrate. There is a division bench order in your favor.
Yes.
And SLP is pending.
Yes, SLP is pending, Lordship. So,
What coming? Gone. You have gone. Instead of coming, you have gone.
yes, Lordship, but some of the these petitioners have never filed the petition before the any honorable Lordship.
So you went to Supreme Court.
Sir, Lordship, some of the petitioners went.
Have gone to Supreme Court.
Yes, Lordship.
What happened? SLP.
SLP is a notice to government, Lordship. It is filed on, it is, next date is on 9/10, Lordship.
So then
For a continent year.
beyond 9/10. Whatever is the SLP.
And Lordship.
Yes.
Kindly request to admit, same order may pass, Lordship.
Yes, same order which has
Yes,
been
Lordship.
passed in all other cases.
That's division bench, Lordship. Same.
No.
No, this is not single bench. This is division bench.
Division bench, Lordship.
Taking note of, we will not allow your writ petition and again force the High Court or government to file SLP and notice and 9/10. We will await the decision.
Lordship.
Whatever Supreme Court grants, you have patience. Whatever Supreme Court says in that judgment on 9/10,
9/10, Lordship.
we will grant you. We have no option but to follow under Article 141.
Lordship.
Learned Counsel, the petitioners were employed as contract employees in the courts in special magistrate courts. In this petition, the petitioners seek regularization of their services, admittedly against a common order dated 12/6/2023 passed by a division bench of this court in WP number 24506/2019 and WP number 8096/2021, a special leave petition has been filed before Honorable Supreme Court, namely SLP C number 17642-43/2023, which is pending adjudication. Learned Counsel for the petitioner submits that in the aforesaid special leave petition, the notice has been issued and the next date of hearing is 7/10/2021. In view of aforesaid submission, let this petition be listed for analogous hearing along with WP numbers 17973, 17978. All this is written, madam. 17979, 18026, 1838.
Item number 16.
Yes. Nobody.
I'm appearing for the petitioner in item number 16. Lordship.
Yes, so that we thought nobody's appeared. So, Mr., will you read the prayer? I tried to read it yesterday, couldn't get it. Will you explain what is the prayer in the petition?
The petitioner before your lordship.
Para 14, how, what does it, read it. Read para 14. What does it say? At least I am unable to understand. Please explain what have you prayed for in this petition.
Petitioner, lordship.
Here is the page. What does it say? Read it. It is therefore.
The petitioner.
No, read first prayer, then argue. We want to understand what is your prayer first before you argue.
Go to your writ affidavit page.
Read it aloud.
One in the nature of animals.
Arey, Mr. Read it aloud so that we can hear.
The animal court may be pleased to issue a writ or order direction more particularly.
You don't want to read, right? We discussed the petition that when a query was put to learned counsel for the petitioner, so when the petitioner was asked to read the prayer clause, comma, he refused to do so. The petition is therefore dismissed.
No, your lordship may kindly.
Read. Read.
Please read.
Read it therefore.
Read it aloud, Mr.
Therefore, pray that this animal court may be pleased to issue a writ or order direction more particularly one in the nature of writ of mandamus or any other writ directing declaring that the pending disposal of the appeal on merits in a wide RA number 179 of 2023 on the file of DRAT Kolkata filed by the petitioner against the orders dated 21/6/2021 SA number in SA number 20 of 2018 on the file of DRT Hyderabad. Transfer to the petitioner's void sale certificate 105 10th May 2018. So. This is my prayer, Your Lordship.
What is the prayer? What have you understood? We have not understood anything.
My humble submission.
No, what is the prayer first? Mr. Rao, please, will you help us?
My
One minute.
My property.
1 minute. We will want to ascertain from you have understood, but you are unable to make us understand. We will seek the help of Mr. Rao.
Yes.
We will. 1 minute.
My humble.
Mr. Rao, 1 minute. So we are not saying that we will not hear you. Again, read. Mr. Rao, please read it and please tell us what do you understand of this prayer.
Declaring the pending disposal of the appeal on merits by the RA so and so and the file
against order of Hyderabad for property transport comprising structure situate development area Rangareddy district TS and as such other orders as this may court deem fit. What is pending? Pending appeal.
The appeal is seeking a direction.
What direction? Missing in the prayer.
Yes.
Read it again, Mr. Counsel. Prayer clause, read it again. We have not read it. Please again read it for our benefit. We are very slow. Yes. Read it again. It is therefore prayed. Mr. Read it aloud.
Your Lordship, yes, Your Lordship. I got the. Actually, my intention that word is stay all about the proceedings against the auction proceedings.
That's word there. See, how callous you are. The client has engaged you. Given you instructions, you are not even bothered to read the petition, which the judges must read, take the assistance of a senior person sitting in the court, and then tell you that it doesn't make sense. We will dismiss the petition.
I'm sorry.
Please read petition, comma. The petitioner.
I'm permitted to amend the petition prayer, Your Lordship. Kindly consider. I'll file it amendment petition today.
That is the first sentence which you should have said. That shows that you have not read the petition at home yesterday. You have neither read it after dictation nor read yesterday evening or today morning before appearing before this court. That's the only thing. The prayer heard Mr. So and so. The prayer made in the writ petition is NRI quota, Mr.
B and C, very submitted representation.
B and C. Representation. Is there any order?
Lordship, page 27, Lordship.
29.
27 starts 29, Lordship.
29. Same like, same order, no? Any change in this order?
No.
Mr. Rao, no change. Mark the presence. With consent of the parties, the matters petition is admitted for hearing. The with consent of the parties, same is heard finally. Then page 29, right? This para 3 onwards, 3, 4, disposed of. You will do it or any difficulty? Huh.
You should find the management quota, B and C.
It's also same, Lordship.
Huh?
It's also same.
Same.
You have to make a representation, then.
In this writ petition,
21, 20.
in this writ petition, 21,
21, 20.
same order.
Same order.
Same in this, same order, page 22, 23. With consent of the parties, same is heard finally disposed of.
This is for postgraduate. Page 23 is your Lordship's order.
20,
23.
same order. Same order.
Same.
Mr. Rao,
I just seen, Lordship.
same order.
Page 21.
23, 23. 21 is cost title.
Yes, Lordship.
It is
Same on
PG.
Same on.
All right, 23. Page 23. With this is item 20, disposed of. You write with consent of parties, huh?
Same order.
Same order.
B and
Which page?
page 21. Same.
Page 21.
223.
21 is cost title. 23.
23. I'm sorry.
Same as item 9.
So this is page 21, 22, 23 is the order, right? Disposed of.
If you
Made, please, your Lordship.
Rule 33B.
No.
No.
The petitioner did not even give the particulars where he has studied.
My Lord, you have stated clearly.
He must have studied abroad and his mother is permanent state resident of state.
Hold it.
Please sit down, Mr.
Krishna. But his only Miller will be considered if he is a resident of, if parents are residents of Miller, Telangana, they will be considered an unreserved category, not a local candidate. Because he has not studied, he did not even furnish particulars where he has studied.
My Lord, I have stated clearly that he has studied in state of Tamil Nadu all along, my Lord. Full education is in state of Tamil
Then
Nadu.
you are not a permanent resident of state of Telangana.
My Lord, ordinarily, during COVID also he resided here. His father has also produced and he has also
No, you
produced.
have resided in Tamil Nadu.
No, my Lord. In state of Hyderabad. I have taken that ground in my affidavit, my Lord.
How state? There is no state of Hyderabad. It's a state of Telangana.
State of Telangana I have resided.
You said a state of
I
Hyderabad.
apologize.
There is no state of Hyderabad, number one. And then you said that I have studied in Tamil Nadu.
Yes,
So
my Lord.
you are studying distance mode from
No, my
here to in Tamil Nadu and got certificates, right?
No, my Lord. During COVID, online
How
education.
can you study here, stay here and study in Tamil Nadu, Mr.?
Due to COVID,
One of the two statements have to be incorrect.
my Lord.
Which, where is it, have you stated that where have you studied first to 10th? Which paragraph of the petition?
My Lord, paragraph 7 I have stated that.
You are in United Andhra Pradesh, that is correct.
Yes.
Student and able to secure decent marks. Where have you studied?
Paragraph 7
Mr.
I have stated that he has studied in the state of Tamil Nadu.
Then
Paragraph 8 I have stated that during COVID he had stayed in Hyderabad. Lord. He has produced his residence certificate, my Lord. Your Lordship recently has held that criteria of residence, my Lord. Your Lordship in the common order.
That is for the persons who studied here. There are two things. One is study, one is domicile. You have studied everything
Tamil Nadu.
from your KG to PG in Tamil Nadu, and you say you are to be considered as a local.
no.
My Lord, based on the residency. Has produced, his
That can't be
father has
done.
also produced.
That can't be done. There should be some basis here. In fact, in all those cases, 1 to 10th, they
And to
studied
10
here.
they had studied.
Telangana. 2 years they have gone outside. So we said if the 2 years, merely because 2 years they have studied outside, they do not lose their domicile status. That is the purport of the judgment. Not anybody, everybody merely by applying become a local.
He is seeking admission under management quota. So you can submit a representation.
Competent and management quota.
Management quota.
Competent quota.
Both I have stated in my prayer.
No. Thing is that your local candidate you can't be considered. Your candidature under this thing will non-local will be considered a competent authority and management quota. Correct?
Yes. But based on the residency certificate, I am relying. Lordship may at least consider for management, my lord, local.
No, it is for Mr. Rao to say.
It cannot be considered.
Let him file then objections. They
Representation.
cannot dispose of or representation if you want.
Not made a representation so far.
No, we will permit you to make a representation, they will consider.
Yes, my lord, permit me to make a
All right. In this writ petition, the petitioner inter alia, petitioner who has appeared in NEET UG examination 2023 seeks a direction.
Yes. Subject to your lordship. Petitioners are before your lordship, my lord. Because of the non-availability of the residential certificate, my lord, the petitioner has been entered in the non-eligibility list, my lord. All the three petitioners, my lord, they have not allowing to under A category, my lord. On the basis, my lord, they do not have the residential certificate, my lord, when they have submitted the applications.
Mr. Prabhakar, A category seats, it's long over 12th or what?
Second phase of counseling. But yes, he did not get himself registered with A category. Now he wants to make A category registration.
No, but A category results are already declared, no?
From tomorrow onward, second phase of counseling is going to be started.
We will admit the petition, right? No, because it was listed for admission. Yes, it back on the bundle. I'll get the bundle and check. No, we myself have been issued an order sheet of these matter.
Docket of this bundle. This good one. I'm not docket. Docket in the docket.
You, I will go through it. You talk to them.
Already studied in Kerala, Mirror. No. A category first round is already over. Now second round also is going to be over by 1 o'clock tomorrow.
Tomorrow.
But can it be considered now? If he gives a residence certificate, he has not even opted for A category, then it is not possible. It's only management quota they have been conceding, so we are passing order. B and C category, not for A category.
First petitioners and other has got.
Make a representation, usual will direct them. You can only make a representation. We cannot direct it to be considered because the date is long over.
Tomorrow is the last day.
Tomorrow is the last date for exercising web options.
For second phase of.
No, second option. But if he makes an option, the petitioner has studied in Kerala. But he is seeking the order, Milord, to be considered under 15% unreserved category on the basis of residence certificate. The residence certificate he did not upload his parents. But there is no time loss. That's what, when we read the bundle, that is what we felt that he is not entitled. That's why we are asking so many questions. Want to make a representation? Make a representation, they will consider like earlier we had one matter, no, category A. Same. Category A. I think item number 8.
Yes,
item number 8 is also. No, your matter only, Ram Singh. Your matter is item number 8.
Yes, Lord.
We permitted you to make a representation, or you made a representation in that case.
We'll make a representation. That may be considered.
Kindly say, Lord, he studied in Kerala. And that, like we said in Tamil Nadu, his studies will mention that he is in studied, he pursued his education in Kerala. However, he could not upload his residence certificate, therefore he intends to make a representation for consideration.
Putting it. Both the matters admitted. Only one. At least these both are admitted. Troublesome person also admitted. Troublesome person. 396. This questions were admitted in this one also on top. The entering order is granted. Now these ideas are filed to vacate. Patients for hearing, but totally new 20 petitions. The interim order is granted. Interim order is granted earlier. Very good. For 2023. One minute, Mr. Rao. 1 minute. Petitions found. Interim order is dated 14 to 2020. Admitted. But hearing 14. Which are applications seeking modification and verification. Modification is also. Yes. No, I will get the published. Published to one perfect application. Madam, we are correcting, do it immediately. The lawyer is after us, like anything. Today morning also he said that copy. Since it was 5 minutes, we didn't say anything. So we are correcting it immediately, do it and give it immediately. It should not take more than 5 minutes for you, 2 minutes for you. All right, yes, I will say vacating stay. That's it, yes. Idea. So we should make it first. This vacating thing is, they should argue first. And it comes. Here.
Let representation.
Is it, sorry, yes.
But we wanted to note the direction from this honorable court
Huh?
or to consider the A category.
A representation, right?
Will file, pressure.
Yes. Mark the presence in this writ petition, comma, the petitioner inter alia seeks a direction to respondent university to consider his claim for admission in MBBS stroke BDS course for academic year 2023-24 under A category. Paragraph. Learned counsel for the petitioner submits that fairly submits that the petitioner has studied in the state of Kerala.
One petitioner state of Kerala, the other petitioner New Delhi.
The petitioner number 1 has studied in the in the state of Kerala, whereas petitioner number 2 has studied in New Delhi.
Study, we had intermediate New Delhi, we had the Riyadh.
And intermediate in New Delhi. Intermediate in New Delhi.
New Delhi. Senior secondary.
Whereas petitioner number 2 has passed the senior secondary school certificate examination from New Delhi. The petition similar. It is petitioner number.
Third petitioner is studied in Muscat.
It is submitted that petitioner number 3 has studied in Muscat
and studied intermediate
and has cleared intermediate examination from
Hyderabad.
The petitioner submits that the petitioner be granted the liberty to submit a representation with regard to petitioners be granted the liberty to submit a representation with regard to their grievance to the university, and the university be directed to decide the representation submitted by the petitioners expeditiously. On the other hand, paragraph, on the other hand, Mr. Prabhakar Rao, learned counsel for the university, submits that in case such a representation is submitted, the same shall be dealt with in accordance with law expeditiously. Paragraph. In view of aforesaid submissions and in the facts of the case, comma, the writ petition is disposed of with the liberty to the petitioners to submit a representation with regard to their grievance before the university. Needless what is this? Section 7. It has to be only by the court. Parties have agreed for arbitration. Okay, only where the arbitration agreement is there, but there is no nomination of an arbitration or unpresent. You can sustain the office of the both will be password. Password. Yes, 26. Keep it here, madam. Next 2 files also you keep it here. Ready. Now. Six. Number signing that agreement between lines. It says administrative side, you can make a request, need not, nobody is afraid. Password. Yes. Next. 27. Password. Password. 28. 26. 27. Yes.
For the source submissions, we are complied with the process. The file is complied.
Complied. Correct. Mark the presence, learned standing counsel for respondent number 6 submits that the direct
I applied for the petitioner in this matter, my lords, on the last occasion on 24/7/20.
substituted service.
Yes, my lords. I have filed an IA, my lords, IA number 3 of 23, my lords, on 28/7/23, seeking permission from this honorable court to take out substituted service on respondent number 1, which is based at Chennai, respondent number 2, which is based on
Substituted service, wow, publication. Substituted service by what means?
in newspaper, my lords.
That's what we are asking, publication. Which newspaper?
In Times of India in Hyderabad, my lords, and Chennai also.
Chennai, they are
Chennai
based in
edition in
Chennai.
Hyderabad.
Chennai and Hyderabad. All right, heard on IA number 28, heard on IA number 3 of 2023.
That we
It has been dismissed from non-compliance of condition.
That the matter comes not against the order of the commercial court. In fact, not on 1st August, not, we filed same matter not as a commercial court appeal. You are not so pleased to not say that appeal was not maintainable. Your not I passed that by the date of filing that was not uploaded, not be filed along with the legal picture. Liberty to take appropriate.
Yes.
Now that I proceed 227 that CRP at 85.
What is the time limit under Commercial Courts Act? Give Commercial Courts Act for decision of a dispute. Will you tell us, senior counsel? No. We are asking nothing to do with your case. Generally asking what is the time limit under the Commercial Courts Act for deciding a dispute. Is there any time limit? No time limit.
Disposal of total arbitration of OP.
Whatever, any proceeding under Commercial Courts Act, is there any provision?
Specific time is not.
No time. Like see Hindu Marriage Act 6 months.
Yes.
Like that we are asking any statutory provision.
Yes.
No, but this Commercial Courts Act has been this thing itself provides for, it has been enacted only to ensure that the investors do not go away from India and there is a speedy adjudication of the disputes under the Commercial Courts Act. In any case, if we have this tentative opinion, we don't think that we are wrong. That the commercial court should decide this thing.
6 months. 6 months.
Appeal is this 6 months, but dispute.
You had here, unfortunately, that OP was dismissed for default non-representation of the council during COVID period.
When was OP filed? You are obviously a respondent in OP.
Yes.
What is OP? What is OP? Opposite party. What is OP?
OP is not challenging the award period because
What is OP? It's not. I'm not getting it. Original petition.
original petition.
See, I'm new to these nomenclatures, no, which is so obvious to you. Original petition was filed by whom?
By the revision petitioner not before the commercial court.
You had filed. You had filed.
Yes, we filed. That is for
No.
17.
They have the petition.
Again is the above.
Filed OS.
Page 14 there.
OS COP number.
Commercial opinion.
Commercial.
COP number 254 of 2017, page 14 there.
What was the prayer in COP?
That COP prayer is not.
A recovery of amount, whatever. Tell us, Mr. You are a senior counsel. This is under section 34, right?
Yes.
Under section 34, 1 minute. To set aside award dated
19th September 2017.
19th September
2017.
2017.
Page 28.
Then
Then there are that
what happened when it was filed?
This was filed 18th December 2017.
Then what happened from on 18th December? Notices were issued.
Then that OP was this.
No. When notices were issued, right?
Pardon?
Notices were issued to the respondent.
Yes.
We want to know day-to-day proceeding, right? What happened?
What happened?
Like if you are not there, then please prepare this thing list-wise date. What happened? We want to know what has happened, like this thing.
Yes.
And here this petition application has been dismissed for default. So then you can file an application for restoration. That has also been dismissed.
That has been allowed, in fact. But on 7-9, that is your notice will get their order. It's page 9.
No. So, Mr. Acha, let us for the thing that this OS was filed on 18/12/2017 by you. What happened to this? It was dismissed for default.
It was dismissed for default.
When?
2/9/21. 2/9/21 during the COVID period. 2/9/21. For the non-appearance of the council on 28/21.
All right.
For non-appearance of the council on 28/91.
One
It was posted further to 2/9/21.
1 minute. Non-appearance on 2/8/21. 12. Then what did you do? You filed an application for restoration. When?
27/9/21 we filed application.
Application for restoration.
Yes.
What happened to this application?
That is
It was dismissed. It was dismissed. No.
No,
When?
By conditional order to pay 6,000 cost.
Date.
7/9/22. 7/9/22.
Allowed with cost of
6,000 rupees. And to find the written statement.
Written arguments.
not written statement.
Written argument. Standard. And for complaints, it is posted to 21/9/22. To report complaints, it was posted to 21/9/22.
Then what did you do?
We paid the cost and we went with the written arguments.
You complied on 20. Paid the cost.
The court insisted that further.
No. 1 minute. You paid the cost on when?
Cost was same day, but on 21, on the date of
21/9/22.
Yes.
And written argument you didn't file.
We could not file because the court insisted you file undertaking that we will not take tax. Further condition.
Written argument. So you should must have told your client that it is the lighter vein, Mr. Counsel. We must. So everybody is so serious. You are smiling. Therefore, we are taking this lighter vein route, right? So you must have told your right that it is our fundamental right to seek adjournment. and fundamental right cannot be waived, and no undertaking can be given that I will not avail of my fundamental rights. So don't agree.
Firstly, to that extent, there
Lighter way, Mr. Lighter.
not said, but like,
Written argument didn't file.
would not be filed anywhere, but court insisted that you must find an undertaking that will cooperate.
No, but where is that order? No undertaking.
Page 8. Page 8.
Page 8 is the undertaking.
Of first 3 lines, not page 8. When the court has allowed the concept of undertaking. But this condition is not there at page 9, but court insisted that I should. Subject to your narrative indulgence, here, but even to find that the written actions and also we are bound to cooperate with the proceedings also, but no further.
But you did not agree there. Nothing wrong with court saying that prima facie we don't see anything wrong in saying court asking that don't turn into a regular civil suit and don't keep it pending for 25 years.
I respectfully pray your.
So then what happened? Yes.
I
1 minute, 1 minute. So 21(9) you didn't furnish in this thing. So what did the court do?
Same day that application for discussion.
Application for what?
Application, this alternate same application that IA 334. Alternate June 9.
Conditional order. Non-compliance, it will reject.
Reasons for
7 which was under.
So this is COP dismissed.
Setting aside.
COP dismissed, right?
IA.
IA order.
But IA was allowed 179.
Correct.
With
It is a conditional order. For non-compliance of the conditional order.
For non-compliance of condition, IA filed on 27/9/2021 rejected. Then
We filed CRP to go to Sanapur initially.
Ah.
Office took an objection that the CRP is not printable. Then we filed commercial court appeal to court in Sanapur.
Then you are correct. Yes, not correctly not applicable.
Then appeal was
Correct. Now what is your submission now?
I only pray that.
You are the plaintiff, so you have a right to this thing prosecute the suit at your leisure whenever you get time. And court should not insist for compliance of condition. And you can't. The judge was very unreasonable in asking for an undertaking that to cooperate with the.
Even I am not saying that unreasonable, but only I say that
Illegal.
OP was discharged from non-representative council. Council filed the affidavit in the case by way of the IA 334, saying that he suffered COVID and he did not know that in August 2021.
No, we will issue notice only after recording your undertaking that you will not seek any adjournment and will argue the petition on the date which is fixed by this court.
And I will avoid your doctor's condition.
And you will waive your fundamental right to seek adjournment.
One last chance to pursue the matter on merit.
Don't, I mean, this all, Mr. You know what is the scope of 34, what is the order, you will know everything. You know everything as a counsel. You know what is the scope of 34, what after written arguments also, and how to file an appeal under section 37. All this is ready in your stock. Only some paragraph to be removed and next day it will be ready.
Even on 29 itself to 21/9 itself, written arguments were ready. But as you
Not filed. No, but you file written arguments here at least.
Yes, it is ready there.
But you will file on the date fixed by us.
Yes.
Yes. This petition under article, in this petition under article 227 of the, you go there, Mr. How will you type today's orders certified today? You are, if you take dictation till 1:30, how will you type? In this petition under article 220, after this you go.
Dates are immediately.
You don't have mobile, can't see calendar.
I have mobile, but I cannot.
Learned counsel for respondent on the other hand, learned counsel for
11th
respondent.
or 12th is subject to your lord's indulgence.
No, not our convenience, but we are fixing
Yes,
it.
sir. We'll be-
That is convenience. You are bound by this thing.
11th or 12th.
12th Monday.
12th.
On the other hand, learned counsel for respondent submits that shortest possible date may be fixed for as the commercial original petition is pending since 2017. Paragraph in view of paragraph it is right. We have considered the submissions made on both sides. It is right law that a party should not be penalized for the fault on the part of the counsel. Full stop. The commercial original petition was dismissed for want of appearance of the counsel. Full stop. The counsel who did not appear has already filed an affidavit before the commercial court. Therefore, for commercial court, the petitioner has already deposited the cost as directed by the commercial court. Therefore, with a view to grant one opportunity to the petitioner to contest the matter on merits, it is directed that the party shall appear before the commercial court along with copy of the order passed today on 12/9 on 11th on 12/9/2023. The commercial court thereupon shall fix a date for hearing of the petition. Full stop. On the said date, no adjournment shall be sought by the petitioner, and he shall file the written submissions and are
Rate for
why you are these people are sitting, that's what it happens. He's sitting today and orders and not in the meanwhile they should type also, they don't type. If we are hearing the case, he will not type sit. Mr. All of you should do when we have given a dictation and we are hearing the other case, don't sit idle. Type. And there are so many CC today. When will you type? You are sitting here and you are not even typing. Six C. 6C is correct, but object is later. However, this sentence should go there. However, the object of science. One thing only, madam. This sentence will come here after supra. Shift this sentence. Rest everything is fine. Bring it immediately. Come. Don't stand there. CC today. CC. No, not today. CC you said. Certified what? So we will instruct them. We have certified copy. Not today, certified. It is yesterday's order, no matter. Date is yesterday. You say certified copy. As per rules. Immediate. CC immediate. CC immediately. Immediately. Immediate. Immediately can be anywhere between our days. Yes. 1 to. CC band 38 immediately because we have issued that circular. Oh, what? Order? Yes.
Subject to your lordships kindly will. That this is a matter, my lord, where a challenge to the rules have been made.
See this and then art. Similar.
Yes.
See the order.
Yes, ma'am.
Please read it.
My lord, Learned Counsel for the petitioner submits that the notification dated 28 June 2018 was issued by the National Council for Teacher Education, pursuant to which impugned notification dated 24th March 2022 was issued for conducting the Telangana State Teacher Eligibility Test. Learned Counsel further submits that the notification dated 28 June 2018 issued by the National Council for Teacher Education was challenged in a writ petition before the Rajasthan High Court, and the same was quashed by a division bench of the Rajasthan High Court by order dated 25/11/2021 in the civil writ petition number 1853 of 2021. Learned Counsel also submitted that against the aforesaid order dated 25/11/2021, special leave petition in SLP Civil 20743 of 2021 was preferred, and the arguments have been concluded and the judgment has been reserved on 10/12/2021. In view of the aforesaid submission, hearing of the writ petition is deferred. However, the Learned Counsel for the parties are granted liberty to mention the matter as and when the judgment is pronounced by the Honorable Supreme Court.
Same order. Find out what has happened.
Right,
Judgment.
We filed an IA, my lord. The judgment has been pronounced on 11th of August.
Quashing the order passed by the Rajasthan High Court.
Is confirmed. Is
You are saying
confirmed.
quashing.
My lord,
Madam, take that order from.
Yes, madam. The notification issued by the National Council for Teacher Education, which was set aside by the Honorable Division Bench of Rajasthan High Court, has been confirmed, my lord.
But what is the latest development, Mr. Rahul?
Well, the rule frame.
No, what is the latest development after Devesh Sharma? Yesterday.
Yesterday, yes, my lord. That case, my lord.
You should also tell that.
Yes, yes. I'm passionate about that, my lord. In this
Again,
case,
one more matter has been admitted in order to explain the Devesh Sharma's judgment by His Lordship Justice.
I may. I may be permitted to, my lord, find out. I'll clarify.
We will record this. What you have placed, we will record. Then what brother has said, you find out.
Yeah,
Yesterday it has happened.
I have gone through that, my lord. In that case, my lord, the process has been completed even prior to the orders of the
Not going through for sufficient, but you will have to convince us if you want us to allow the writ petition, right? Place what is the issue involved in that? Correct?
That subject to what, lordship?
No, orally saying you know it, you have read it, but we have not read it. So whose satisfaction matters?
This judgment, my lord, is not.
No, whose satisfaction matters?
Your lordship, my lord.
We have to decide. So please, we are telling you that please place it on record, whatever, and then argue that this issue involved is here different and that thing is different. Then we will consider. It has to be there. We don't know. Right?
My lord, in this matter,
Sent.
my lord, in this matter, I am appearing for NCT, my lord, the respond number 2. Kindly, my name may be directed to printer, my lord.
You know what is the issue? No.
Yeah, I am.
He doesn't, you, Mr. You do it.
May I only
So that tell him what all is transpiring, because we won't like to repeat it again.
May I only request a short date because the next TET exam is being conducted on 15 September 2023. The teacher eligibility test is being conducted again by the state of Telangana on 15 September.
No,
But,
sir.
Therefore, I may only request.
This is covered. Mr. D, SLP has been dismissed.
Yes, my lord.
Judgment of Rajasthan High Court has been upheld. So what?
Upheld in the.
Then you have to follow, no?
Yes, my
That
has been upheld.
what time and name and time? Huh? What name may be printed? Nothing may be printed now. It will be disposed.
Only thing is that, my lord, basing on that judgment of the Honorable Supreme Court, the petitions have to be disposed of.
Then?
Yes, if at all my lords are fixing any date,
To amend minimum qualification. So this, but how can we see? Amend.
Counter is also not filed.
Form was already filed.
By the state,
By
it's
the
filed.
state, by NCT.
NCT not.
No, Mr. What is the prayer in the petition, Mr.
Relying upon the notification which is now standing.
No, prayer.
Yes,
in the
I have sought for, my lord, setting aside the rule at page 16, my lord, that's right. The reason stated below, the Honorable Court may be pleased to issue writ order direction, particularly one in the nature of writ of mandamus, declaring the impugned amendment to minimum qualifications for TS State Paper 1.
So what you want to say that exactly similar provision was in challenge before Rajasthan High Court, exactly similar, and that has been set aside by Rajasthan High Court and SLP dismissed. Let him find out. Why don't you give us a chart that this is Rajasthan provision, this is Telangana. We find out at a glance that it is identically worded. Have you annexed it? Annexed it? No.
No, my lord, I have annexed the judgment of the Honorable Rajasthan High Court, my lord, but I will, as your lordship pleases, I'll prepare a small annexation.
So Rajasthan High Court, is there a provision quoted? Provision quoted, Mr. Must have been quoted.
But they have
not quoted.
No, ma'am. They have challenged the notification of the NCT directly saying that E8 candidates cannot be permitted to take the.
No, what is your submission, Mr.? Please formulate. That identically worded provision was there in the Rajasthan, which has been quashed by a division bench, and SLP was preferred against that order, which has been dismissed. Is it correct or not correct?
No, my lord, identical rules have not been framed by Rajasthan High Court, my lord.
Then how does it then the Rajasthan judgment help you?
Lord, the NCT notification number 246, my lord, which is become the basis, my lord, for permitting Bachelor's of Education to take the teacher eligibility test has been.
No, no, what is NCT notification?
That your lordships would find at page 32.
Date.
The state, yes.
Date of NCT notification. Date of NCT notification.
28 June 2018. Malad.
So now we understand that
The state of Telangana has amended its rules, Malad, relying on this notification on 23rd March 2022, wide GOMS number 8. It is under challenge before your lordships.
1 minute. So notification dated 28/6/21 was issued by whom?
28th June is issued by National Council for Teacher Education.
NCT.
Yes.
So you want to say that notification dated 28/6/2018 on the basis of the notification dated 28/6/2018 issued by NCT, the Telangana government has framed rules. And that NCT notification has been quashed by the
Rajasthan High Court.
By the Rajasthan High Court, SLP dismissed. So therefore, what like this in
that rule,
therefore the rule enacted in pursuance of this notification cannot survive.
I am grateful.
This is what
I'm grateful. I'm grateful.
Fine. We still remember somebody told that he is not so young. We were yesterday, we were telling you young counsel. So one senior counsel said, oh, he is not so young, sir. You remember?
Yes.
We will give him time to examine this, fix a date. Shortly. Yes, in this petition, petitioner has assailed the validity of GOMS dated 23/12/2015, by which what rules?
GOMS number 8, my lord, 23rd March 2020.
72. What rules? Name of In view of aforesaid submission, learn it so and so and so and so. Pray for adjournment to enable them to examine the aforesaid aspect of the matter. Print the name off, otherwise you will not know when it was. Huh? Even though we are giving a date, you will not know until it is printed, right? List on. This all updated. Nine. 4th September 23. Give Mr. What is this thing issued by NCT? What is the rule comparison? How it can't survive?
I'll make a small synopsis and place it before you.
Not synopsis.
Synopsis.
Not necessary. We have worked hard to write all this.
A tabulated format.
And formulated submission for you also.
Great.
R1 and R4.
Lord, it is coming up for filing of counter by the 4th arrest.
Admitted for the, Acha, Mr. This is a dispute between a government company and the state.
Yes, my lord, a fully owned company by the state of Andhra Pradesh.
Why should you, this thing, explore the possibility of mediation?
My lord, we have been requesting them, as my lords could see from the counter.
Not necessary to fight out everything and at the end paying along with 24% interest.
My lord, all that they say is money is not released by the government. Everything is admitted.
Fees amount, my lord. Recovery of fees amount. Contractual obligation.
You can settle, right? Supposing if we admit it, you file counter after 3 years. Petition is decided thereafter, say another 3 years. So 6 years, no, 6 years, who will pay interest? He is entitled to, he will say, I am entitled to the amount which is admitted. Who will pay interest?
Yes, I'll get instructions by short.
Not instruction, Mr. We are referring it for mediation. You get it. There is a mediation center here.
Yes.
What is it called? Mediation center next to the High Court. Where? Who heads? No trained mediator. But this is small now, he will not be busy. He will not get time. Open the. We will request Justice Ram to mediate. The party should appear before this mediation center.
This may make one respectful sub. My lord, everything is admitted. All that they say is money has to be released by the government. That's all, my lord.
You don't want to go to mediation?
No, I would go, my lord. If my lord's direct, I have to. We'll go, my lord.
Everything is admitted. The question is, he doesn't want to file counter. We will grant 4 weeks time to file counter.
My lord, I would.
Petition is admitted for hearing. 4 weeks time is granted to respondents to file counter. This is mandatory, Mr. Section 89. Basic you should see. You cannot say that everything is admitted. Give me today. We don't have the check. Otherwise, it's not that we are signing it today. How can you resist the prayer? The bar has to cooperate. Alternative dispute resolution.
My lord, I would go. My lord's me. I'm sorry. I would go.
Admitted for hearing.
My lord,
just a minute. Give the file. In this writ petition. This writ petition has been filed by by a government company government company against the state of Telangana
Of Andhra Pradesh, government of the Andhra
seeking,
Pradesh,
huh?
of the Andhra Pradesh state.
Not state of Telangana.
Not.
You are respondent number 1 in the petition.
Yes, this petitioner.
The petitioner, a government company, namely AP State Film, Television and Theatre Development Corporation Limited, a company situated in Andhra Pradesh, has filed this petition seeking a direction to respondents number 4, 5 and 6 in the writ petition to release undisputed amounts of, it's all amount of rupees 4,07, 71, 134 to the petitioner along with interest. Paragraph. Learned counsel for the petitioner submitted that the aforesaid amount is due, is admittedly due to the petitioner and has not been, and the entitlement of the petitioner has not been disputed by respondents. Full stop. However, learned GP for revenue prays for adjournment to enable him to seek instructions in the matter and to make a statement. Paragraph. Taking into account the fact that the dispute is involved between dispute in this writ petition is involved between a government company and the state of Telangana, we deem it appropriate to refer the dispute for settlement before the mediation center annexed to the High Court. We request Justice C. Kodandaram, former judge of this court, to mediate the dispute between the parties. The parties undertake that they shall appear before the Mr. Justice so and so in the mediation center on which date?
2 weeks henceforth, dates subject to
date.
It's on a regular date, not on any Saturday. Sorry, my lord.
Date.
It's a regular sitting or
12th of September. 12th September.
Yes.
12th September 2023 at 3 p.m.
Great.
We must at least try it. That's what we don't know to what an extent, but at least we are under an obligation. This is not a private parties. That's why we thought of.
Great.
Yes.
In this matter, with apology, I am appearing for respondent number 7. I am seeking with about 1 week time for filing.
Petition is admitted for hearing. Let counter, if any, on behalf of respondents be filed within 4 weeks. Next.
May I please, your lordship? I am appearing for the petition of the lord.
Ask him. He is there.
Mr. Counsel. See, the Lok Adalat award binds only the parties.
Yes.
Correct?
Yes.
It's not a party. The petitioner is not a party. It doesn't bind him. He is not a party to the, even before the lower court, which has been referred to Lok Adalat, he is not a party. It only binds the party to the award.
Your lordship, with apology, I will clarify. The previous contentions of the petitioner is that he is not a party, he is the Lok Adalat order awarded is not binding to him. This is the main grievance. I will clarify. Respondent number 7, who is there, according to the petition, he is the original owner of the property. Now, second thing, their documentary, this petitioner is have not completed the agreement to complete the document. And this petitioner also, my lordship,
We'll see, we had that doubt.
no, hang on. One apology, lordship. Lordship may be given only 1 week time because we
No, 4 weeks time. There's no hurry, right?
the interim order is there, man.
Let it be there.
Interim order is there.
We can't, in all cases, interim order is passed, we cannot do anything. You file vacation of stay in case you are agreed.
Maybe only 1 week I have not filed Vatal because they are on the basis.
Yes, next case. Yes, sir.
My lord,
33.
may I please your lordship? I'm representing the petitioner, my lordship. This matter is coming up for instructions of respondent number 1, which is the
Matthew Koshi.
Petition, yeah.
Who appears?
Yes, I am appearing, my lord.
You look very, this thing innocent, but allegations against you are very, this thing that you are harassing.
My lord.
You are appealing for the.
Respondent.
One and two minutes.
Matthew Koshi. The allegation is against respondent number 2. That you are harassing, Mr.
My lord, he is only the investigating officer.
No, sir. Investigating officer of Lokayukt is not meant to harass people. So, that's why.
Issued notices, my lord. That's all. 3 times he has issued notices.
What did he do to harass you?
Just look at page number 29. I have filed a detailed affidavit.
Pleading.
My lordship, petitioner.
Pleading, what did he do to harass you?
Yes, my lordship. Petitioners are the women members of Presidential Welfare Association.
Correct. Whatever members,
The investigation.
What he has done?
Yeah, 3 things.
Where have you pleaded?
Paragraph 8 and 9, my lordship. My petition. May I read, my lordship? Page number 14, paragraph number 8.
Harassing? How harassing? Everybody you can say that we are harassing you because we are asking questions to you in a case. There's no harassment. This is as vague as it can be, harassing petitioner association.
My lordship, what has happened is this respondent number 2 is Mr. David Koshi. He calls up at odd hours to the women members of the society.
No, Mr. Issuing notice on a complaint is harassment.
No, my lordship.
No, supposing if he doesn't do it, then he will be this thing pulled up by Lokayukt that you are investigating officer not doing any action. If he takes action, you say women members harassing. He has not done anything. Did he visit your house at night at 2 a.m. in the
odd hours?
2 odd hours. Where?
Page number 29. I have filed a detailed
29.
Page number 29, my lordship. Not only visiting the
No, in the affidavit, where is the averment?
My lordship, I have briefly produced at paragraph number 8 and 9. In addition to that, I have filed a detailed affidavit which I have already filed before Lokayukt. My only humble submission is my application of this complaint, allegation in this affidavit may be taken up. That's all I am praying for this, my lordship. I have submitted video recording.
Taken up by whom?
Lokayukt itself. I have filed a complaint before Lokayukt in the ongoing proceeding.
Who appears for Lokayukt?
I am appearing. 1 and 2, I am appearing.
In fact, I have produced CDs.
How will he take action? He is the one and the same person. Lokayukt and respond number 2, one and the same person.
And my lordship, I have produced even the
same, like it's from what?
My lordship, my humble submission is my complaint should be, allegation should be investigated.
Like it's like leaving a goat in front of a tiger. He is a tiger. He will kill you.
But allegations are really serious, my lordship.
That's why. No, what you are not telling anything. We don't see harassing the petitioner and to issued notices. That is what is paragraph 8. And then we don't know.
Goes on to say, let us settle the matter out of court. He is pressurizing the women members of association to get the matter settled out of court. Otherwise, the things will be very seriously looked upon.
So, have you responded to the additional affidavit?
The additional affidavit is filed, page 29 to
29. Complaint.
Page 92,
29 is complaint.
Yes, my lord. It is my complaint before the Lokayukt in the form of affidavit about this harassment. I have provided the proofs in the form of CDs, video CCTV recordings,
So we will request the local, we will direct the Lokayuk to look into your complaint and dispose of.
That's all I prayed, my lordship.
That's it.
Yes, my lordship.
And my lord, in this matter, already he has given report. R2 has given his report and.
No, Mr. In such cases where there is a conflicting thing, you will be well advised not to appear. Professionally, it is not proper. There is a allegation against you in personal capacity. You are appearing for Lokayukta also, for him also.
Yes, my lord. IO is none other but the part of Lokayukta. Is IO investigating officer in all investigating officers.
Mr. Supposing if he would have implemented investigating officer institution of Lokayukta, you are perfectly justified. But the problem is your name appears in personal capacity. You have been implemented, and despite that you are appearing for Lokayukta. Shouldn't appear. We are not writing anything against you in the order. You asking you to be careful in future. It's a case of conflict of interest. He is implemented in personal capacity, not as investigating officer. He is part of Lokayukta institution, but he doesn't get a license to harass people. And you understand, right?
Yes.
Read in between these. Don't appear for such people. He should have engaged some other counsel. You say that I am appearing, I am a counsel for Lokayukta. I will not appear for you in this case because you are personal capacity. Will direct Lokayukta. Mark the presence with consent of the parties. The matter is heard finally. In this writ petition. Investigator to complaint into petition of association. This is the complaint that constructed in that connection. By investigating in the complaint dated 28/7. They have made a complaint, no? Petitioners have made a complaint dated 28/7/2020.
26/7.
28/7/22 against Mr. Respond number 2. That's. We are only adding the date, nothing.
It is
And
26.
don't appear, correct? You realize now,
Lordship,
shouldn't appear. You realize now? Shouldn't appear, yes.
Lordship, it is 26/7.
Please go to page 35 and see 28, your own affidavit says 28/7.
What is this, Mr.?
Page 35.
Yes, my lord.
Then
He said 28/7.
Then he would have said that there is no complaint on 26/7. Again, you would have rushed correction of order. Huh? 28/7, madam. Complaint dated 28/7. Yes.
Applied.
Actually, 34.
Your Lordship, may kindly have this matter any day next week, Your Lordship. Council is out of station.
No, nothing. This is a PIL.
My lord, sir. It's a case of suicide, my lords, in fact. The report has been.
Let him. This all status report, etc. is complete, right?
Yes, my lord.
But he pray for learned counsel for the petitioner.
My lord, sir.
Prays for adjournment on the ground that the arguing counsel is not available. He is out of station list after 2 weeks.
Achha,
May it please, Your Lordships.
Counter.
Present public interest litigation is filed, Your Lordships, where illegal encroachments have been made into agency lands.
Advocate for hearing. Counter, if any, on behalf of respondents be filed within a period of 4 weeks.
Your Lordships, it says that IA2 is for implement of Gram Panchayat, which is still pending before.
Issue notice of IA2 of 22 to propose respondent.
I'm grateful, Your Lordships.
37.
We require 4 weeks time for filing of counter in the matter, Your Lordship. We are appearing for the respondent number 2, 3, 5 and 6.
Admitted for hearing learned counsel for respondent number
2, 3, 5 and 6.
4 weeks
There's an
time.
interim order.
Interim order, if any, shall continue. R1 and R2 counter.
I'm okay for R3, we filed a counter.
No. Mr. 1 and 2, you don't want to file despite opportunity being granted on 2nd of August. Municipal administration and urban development.
And application. Municipal administration.
No, you are, Mr. Srikanth, you are appearing for second respondent, district collector.
Second respondent counter is required, my lord, in this case. Second respondent counter is required.
You are appearing for municipal corporation.
Yes, sir. Third respondent.
Third respondent.
Let counter, if any, on behalf of respondent 1, 2 and 4 be filed within a period of 4 weeks. Don't even know, right? Open the file here only. This not again we are telling Mr. This is not invitation. Wedding going on so that we invite and you have.
Will have 3, this one number 3.
It's your outlook, don't fight. Nobody stands up also. Yes.
Yes, call them.
Subject to the Honorable Court kind permission. Your Lordship, rejoinder is filed in the matter, Your Lordship. We need 3 weeks time for the instruction. There is reply affidavit filed in the matter, Your Lordship. We seek further time for seeking instructions from the authority. Item 39.
7 and 8.
Admitted for hearing. Who are you, madam?
2, 5 and 6. We are for irrigation.
3, 5 and 6. Praise warrant is granted 4 weeks time to enable her to seek instructions in the light of reply filed on behalf of the petitioner.
Deeply obliged.
R1 to R8 counter.
Respondent number 4 seeks time for filing counter. GHMs. 2 weeks.
Admitted for hearing, let counter, if any, on behalf of respondents 1 to 8 be filed within a period of 4 weeks.
Published.
My lord, sir. Your lordship passed the directions, my lord. Apprise your lordships on 3 aspects, my lord.
Disciplinary proceeding.
My lords, so far 4 witnesses were examined and 1 witness is being examined today. As far as the petitioner
How
is
many
concerned,
witnesses?
my lords.
How many witnesses?
My lord, so far 4 witnesses are examined.
No, no, how many witnesses in the departmental
My lord,
inquiry?
as far as
Yeah, one memo we have filed with all the details here.
all, my lord, so the petitioner's examination is scheduled on 8th of September, my lord. After the examination of the petitioner,
8th of September.
8th September is the
So
last.
those grievances stands redressed. Then,
My lords, as far as the criminal case is concerned, let's see.
so no, Mr. 4 witnesses in the departmental inquiry examined, petitioner shall be examined on 8th September,
8th
that we have
September.
understood.
And one, yes.
So what time the D will be concluded?
My lords, the maximum span of my lords, 4 to 6 weeks, the departmental inquiry as against the collector will be complete and the
Up to 30th September, shall we say?
My lord,
30th September
my lords, your lordship may
or 15th October.
15th October, your lordship may kindly. My lords.
1 minute, we are just listen to, then you can make submission. Then directing principal secretary to initiate prosecution for producing forged documents. Tehsildar has filed a complaint which is required to be supervised by principal secretary.
Yes, my lord. As far as
you
the
will do it.
There are 2 departmental inquiries, my lord. As against the Tehsildar, the joint collector Hyderabad is, my lord, conducting the departmental inquiry. 15th October, my lords, I will also, my lords, inform your lordships about the status of the.
No, this is something different, right? To initiate prosecution 13 to 15.
My lords, that is pending in CC 11388.
So what he says that it should be supervised by principal secretary, revenue.
Well, the matter is seized by the criminal court, my lords. That also the process of commencement of trial will be hastened up, my lord. Will advise the public prosecutor to go ahead with the trial.
This complaint is pending in CC number
11388 of 2019.
11388.
Yes, madam. On the file of 12th additional chief metropolitan magistrate, my lord.
12. Or CC of which year? 1113
2019 by
19. This is what your instruction is.
Brother, obviously the Advocate General has not been briefed. They should not have been properly briefed by his instructing counsel and the clients. The reason is very, very sad state of affairs which would.
No. This all sad state of we have heard and 3 pages written. Thereafter, you are arguing. The 3 directions have been given.
Yes.
So we have asked them. Disciplinary proceeding.
They are in a hurry to finish off because it's an eyewash. The concerned people.
We can't see that we cannot conduct a department.
I'm not saying. Your lordships will see through the game. If an eyewash inquiry is being done.
This is not you said. You said last, Mr. Please see your submissions. No, please see the submissions. You are now improvising and moving on to next level. We were in this. Please see this. Please, for our sake, we have not read it. You please read what submissions you have made. Please read it aloud. We were on that. You are now on the next level. That it is an eyewash.
I just
please read.
Feelings of this.
For our benefit, please read. Learned senior counsel.
Despite orders of this court, the disciplinary proceedings have not been concluded till today against the collector. The complaints are required to be examined as witnesses in department inquiry which has been instituted against the collector. That they have not.
Number 3.
Direction issued by the Secretary of the court as contained, directing the principal secretary revenue to initiate prosecution against the respondent 30 to 15 for producing fabricated 40 documents. However, despite the efforts and direction, it has filed a complaint which needs to be supervised by the principal secretary revenue
and a proper investigation is required to be conducted.
Oh, 1 minute. So we were trying to ascertain while you were not here from the Advocate General. What about this? Advocate General has said 4 witnesses have been examined in the departmental inquiry. Proceeding in the departmental inquiries, you will be examined on 8th of September 23. Endeavor shall be made to conclude the departmental inquiry by 15th October 23. This is the submission. Second submission, he said, the first and two, this is what he said. Third submission is, he said that this complaint is pending before the criminal court in CC number 11388/2019 before 12th additional chief judicial magistrate, and public prosecutor will be instructed to take steps for expeditious disposal. In case you feel inquiry is not being done properly, you can file a petition there and seek additional direction, whatever.
I'll make 2 or 3 submissions. The Lordship will see, Lordship will kindly take up copy.
No. So, Mr. So we must know before you argue. This is not for final hearing, number 1. 1 minute. Let us understand the scope of today's proceeding. We were thinking that we will ensure compliance.
That's what.
Now you are arguing something else.
No, I'm not. I'm only elaborating on those. But what has happened is,
Yes, please.
on the previous occasions, the Advocate General gave an undertaking before this court that the charges would be reframed against this officer.
My lords.
And they have reframed and then go ahead. I'm ready.
Give your submissions in writing, then we will again record and we will put it to Advocate General. Find out, Mr.
Yes, sir. 8191 of 23.
What are the submissions? Can you?
28 to 23.
Submissions are there.
It is there. 28 to
It's
23.
recorded in writing.
Yes, right.
1, 2, 3, 4. So we can make them part of the submission and give him time.
My lords, in terms of the orders passed by this honorable
But we must find what is the scope of the writ petition. Are we traveling beyond?
Yes,
What is the prayer made and what is it, are we doing?
My lords, the orders of the court has to be complied with.
Give me 2 or 3 minutes, not I'll just point out. Your Lordships may kindly have a look at the report dated 13/12/2017. In fact, your Lordships may kindly have a look at the docket proceeding dated 1/10/2019 in WA 656 of 2017. I have extracted in my memo. There are orders. USR 83191 of 23. Dated 28/2/23. WA USR. 28th of February. Memo. A4 small size. 83191 of 23. I have an extra copy. I just invite your Lordship's attention to the orders of dated 1/10/2019 passed by Son Court in WA 656.
1 minute. We were looking at the prayer clause at page 68. You have prayed for 5 reliefs to take action on the legal notice. Second is to recall NOC dated 8/12/2019. Third is to demolish illegal construction. Fourth is to award 1 crore damages to the petitioner. And fifth is disciplinary proceeding against concerned respondents. Correct? This the main prayer. It will be decided in due course.
Yes.
For the time being, last date of hearing, you said there is urgency, nothing being done. We wrote a 3-page order. He is reporting compliance. Now you are making some other submissions which are not recorded. It's not pointed out, it's not on the file.
I think I did not convey myself properly. I am only requesting this court to please kindly have a look at the orders of this honorable court in WS 656 of 17 dated 1/10/2019.
No, you are referring to some memo which is not on record.
It is there on record, but I think it is not placed in there.
No, it has not come.
Maybe it's not.
When have you filed the memo? When the memo you have filed?
That's on 28th of
He is
February.
entitled to copy also, right?
28th of February.
Memo you have, Mr. Advocate General. What date, madam? This memo is dated?
24th August.
28th.
28th.
24th August, yes. Dated 24th August. It's filed it on 28th. Not standing. It's telling you. Or your lordships may have that 230 minute, we'll see that the memo is placed before your lordships.
No, why 230? Like you argue, right? This is, we have other things to do apart from this not going to be disposed of. In any case, we are going to give him time, you finish it off.
I may submit
I only want you to look into that.
My lord,
That's an extra copy. The lordship may kindly have
So
look at
what submissions have you made which we can be incorporated?
page 2, my lord.
No, submissions you said I have incorporated.
Yes, page 2. What? Para 3. This is a representation. Para 3, your lordship gets it. It begins the inquiring authority.
No, so this is the final relief claimed by you in the petition.
No, my lord, your lordship, see the order. The Honorable High Court, the last para, page 2, the Honorable High Court in WS 656 of 17 and batch wide order dated 1/10/19 recorded as follows. Learned AG would inform this court that names of the witnesses to be examined in the course of disciplinary proceedings has now been finalized. We placed the list of witnesses before this court. Sri J. Prabhakar, learned counsel appearing for the respondent petitions would however state that the list of charges framed against Mr. Naveen Mittal require a rule in terms of the survey numbers having been mentioned incorrect by them. Would further state that the memos dated 19/9/2019 and also 1/10/19 would shed light on these aspects. Learned AG states that these aspects of the matter would be examined and seek time to report as whether there is any necessity to reframe the charges. That my let look into it.
Yes, all right.
If he looks into it, that's it.
Correct.
Then, my lord, page 3.
We will, this order is, it is final and attained finality, this order not
This order has
satisfied.
finality.
Then we will ask him to what he has to
Next,
say.
at page 3, my lord, again. 22/6/17. The inquiry officer shall examine the entire records relating to the grant of NOC and the documents referred therein before recording is concluded on the guilt or otherwise. The entire record is not now placed before the inquiry officer. We requested before the.
There is an order.
There is an order.
That we can't.
But that's why I want him to look into it. But if he looks
in terms of the orders, my lord, the inquiry has to be conducted. It is,
no
while proceedings are on.
If my lord looks into it.
My friend, my lord, sir, at this point of time, unless the report is, my lord, concluded, the inquiry is concluded, nothing can be found by my friend at all.
No, but this part is to be.
Certainly, that has to be followed.
The other aspect is, so far the criminal case is concerned, Lord, it's a sorry state of affairs. I'll just pass on something which will shock all of us. 2019, till today, summons are not served on the accused. 2 accused died. And 3rd accused, and in fact, it's our case that this is not an investigation at all. The whole investigation is.
So what should we do according to you? What direction?
It's a case where it has to go to CBI.
There's no prayer,
There is
nothing.
an application filed by me, separate application is filed. But this.
We will list it then for consideration of CBS.
And not you will see page 73 of this. You are from 2019.
No, but there is no main prayer in the petition for CBI inquiry.
There is a prayer. My writ appeal is to that extent because the single judge refused to send it to CBI inquiry. My writ appeal is on.
We read out at 60A the prayer in the writ petition. Is it correct or not?
There is an application.
60A. 60A page, we read out like 5 reliefs to you claiming. Now you are saying which is not there by way of an interim application.
Interim application is also there in the writ appeal. That I
No,
filed.
no, but you cannot enhance this thing until.
Subsequent event also, this court will take note of the events. Virat.
There's no prayer. In the main appeal itself, you can't, you can widen the scope of writ appeal. Wait, please tell us Where have you this thing pleaded before the learned single judge relief of CBI?
Appeal I have pleaded.
No, writ petition.
I'll just check. I need some time to look at it. But in
Then I will just like CBI inquiry, all the, so we are, so many things, Mr. Senior Counsel, we understand that things may have gone wrong in this case. No, this issue. We will decide it. But too many things you are pressing at same time, like three things, then these two things, then CBI inquiry. So this cannot be ordered today. That will be dealt with when we hear the petition. But before that, this question will always remain. When did you ask for the prayer before single judge for CBI inquiry? Number one, we will ask this. And where in the writ appeal you have prayed for?
I have prayed a specific prayer in the report.
So in the writ petition, did you make a prayer?
Regarding subsequent events, this court can always note the prayer. But why I am saying this is two reasons. Your Lordship,
That's a different point. That's a different point, that the power of this court to order CBI inquiry, notwithstanding the fact that I have not pleaded, is not taken away. That's another thing. And you can seek by way of an interim prayer also, interim application also.
It is also that
These submissions, what are different than answering this basic question? Did you claim it before single judge?
I said I am not very sure.
Please answer that. We are telling you, please answer this on the next date of hearing, not asking.
Why prima facie, just in order to enable my friend to look into that is, what has happened here is, they made a simple application for NOC, but just 2 minutes your Lordship will give me. The backdrop, unless I explain,
No, in any case, we are asking him to do all this and the previous, this thing, and these orders, he should ensure that 1/10/2019, 22/6/2017. He has said that it will be done. He is making a statement.
The disciplinary inquiry, my friend, I have absolutely no problem.
Your grievance, like you are being examined on 8th September also, we are recording this.
Yes.
He has said 8th September complaint will be examined in the department.
Briefing of charges also, my friend assured he looked into that.
We are recording this, all this.
That's concerned.
But at this point of time, we don't think that we can order CBI inquiry without hearing.
Saying that prima facie it requires a relook or at least a reinvestigation by appropriate orders, maybe by instructions. He is for this reason. But what happened? A simple NOC application is made to say that we want NOC because we are applying for THMC for permission. 3 applicants made an application. Now the learned collector then makes an inquiry. Declares that the applicant has
You have all of a sudden you have copied such an urgent mode. This petition is pending since 2017. This is only my 6th week here. All of a sudden you are going to got a court slip, got an order running into 3 pages. We will hear it. What's there? We will hear you at length. We will admit this appeal. Hear it your length.
Appeal is already admitted.
Then why it is coming up repeatedly?
No, it is coming up because the court was very clear that they are not.
Acha, you got it, this thing on a mention memo.
Yes.
That's why it's coming up.
My lords, your lordship may consider to post it in after 15th of October. My lords, the compliance of the order.
Inquiry and all that prayer,
My lords,
1 crore compensation.
my lords, that's
we
a
will
matter
have
of course. If that is the
construction and demolition, etc., we will consider.
my lords, yes.
But there is a direction to submit a report periodically. That is why the matter is coming up. The first direction is to that matter went to SLP. SLP was confirmed when the interim orders were passed because this court was conscious that nothing will be done by them. Today, what they say is in the criminal case that some false document is filed and 3 non-entities are being prosecuted. The real people who are occupying the property are scot free. Your lordship will see the government collected a stamp duty of.
No, probably there is some provision if with identity, some provision the person who is not included and there are regulations against convocation with the application for including them as actives. Which provision?
No, Mr. Bhavata, if a person.
I do not.
Please.
See, I'm obliged.
In a complaint, if a person is not named as an accused, can you not file a petition, protest petition or whatever it is, to say that the person who is actually to be named arraigned as an accused has not been accused, arraigned.
This all cannot be decided in a writ appeal, right? Where you are claiming this that who should be arraigned. We don't have any means.
My lord, remedies are available. Remedies under the respective laws are available.
I answer your lordship, sir. But there is a
No, there is no prayer for aiding anybody accused. The list in prayer clause.
doing that in a writ appeal and conscious. But what I am
Which
saying is,
prayer?
I have produced evidence to show that all this money has brought from a third party. And third parties are, the investigating machinery is not with me. I can only give information. But investigating has to be done by them.
Here.
I can't have access to the
Here.
bank accounts.
Not there.
So this is the reason where, that's why your lordship will see I have filed a separate memo. I filed two memos.
You agree to definitely do. But the problem is, what can we do to this? Asking.
846 of
Ask.
Lord, today I can only give information.
Where is the prayer? In the petition, appeal or writ petition, we would just want to see.
In the writ appeal, there is a direction, there is a prayer.
No. Where, which page?
It is therefore page 11 of my writ appeal number 693.
693. What is 693 but? 690.
It is therefore prayed. Appeal number 693.
Same thing, 1 crore damages, same thing.
693 the different.
But what can we do? Right? We have to hear. What can we do? We can hear, we have to hear your appeal. What else? I mean, I really don't know.
Is one more.
It has been admitted, we will fix it.
The difficulty is if the investigating authorities are not properly.
We understand that you file an application for urgent hearing and say that it should be heard urgently because it is pending for 6 years. Strictly understanding. But this thing, every time it is listed for report, you argue how, I mean, piecemeal, which can't lead even to disposal of this writ petition. Does it help us? We were just wondering, Mr. It's a pleasure to hear you. You are a senior counsel. We have heard you several times. It's a pleasure to hear you. Please tell us, every time it is listed, you argue. See, this has happened, this has happened. You are aggrieved, you have been cheated, whatever has happened, fraud has taken place. But we have to hear and decide in order to find out whether accused should be impleaded, whether CBI inquiry has to be done, whether damages of 1 crore have to be given or 10 crore, whether demolition has to be taken place or not. All these prayers have to be decided. After hearing the parties, the interlocutory stage you argue, what can we decide? Which prayer?
Subject to my lord's kind permission.
We wanted to see where you have said that these
page
people,
11,
you just now you said that
Page
some
11.
3% should be arrayed.
It is therefore.
Where is that prayer?
It is therefore sound court may please allow the writ appeal and consequently direct the CBI inquiry into the list whole issue. Direct prosecution of respondents and award compensation of rupees 1 crore.
Yes. So only 3 petition prayers. Direct CBI inquiry number 1. Then
Prosecution of all the respondents.
prosecution of all respondent and compensation of 1.
13 to 15.
So now demolition, etc. you have given up.
No.
In the writ petition, demolition prayer was there. Writ appeal, you have inserted a new prayer of CBI inquiry and given up demolition thing.
Still remains
right.
Mr. Yes.
Subject to my lord's kind permission. I may be pardoned. If I
No. Why should
one clarification, the prayer with regard to CBI inquiry was also made by way of an interim application, the being represented by learned senior counsel. That application was considered, the court was not inclined at the stage of admission of writ appeal to go for CBI inquiry. There was a direction to complete the regular inquiry against the officer and criminal case. Now, that is the position, my lords. That's my humble submission. 22nd June 2017.
22nd June. Where is the order?
It's part of the writ appeal.
That will have enclosed a separate set of orders are enclosed.
Prayer was made in MP number 1370.
June. Which writ appeal order was passed?
There was a common order passed in all the writ appeals.
22nd June.
That is order dated.
2017.
Yes, my lords. 22nd June 2017. Writ appeal miscellaneous petition 1370.
Is there in the compilation of why this is why it's
Where is separate common?
USR 388.
Where is the order dated 22/6/70? Separate order, it must be there.
May I request take up this booklet, there's a separate booklet we have compiled all the orders. That order is also found there. Booklet even? 12/6/19. USR 30084 of 19. In that at page 4, your lordship gets the order.
22.
Well, this is what I was trying to point out. May I, page 16, your lordship gets it.
That's rather page 23.
Point of page 16 for a moment, your lordship. Of this. Page
We will hear it at the end of the list. Because why all others should be kept waiting for interlocutory matter. So it is why it has come up today for direction petition, received document, direction petition, fix early date. These IAs we will decide.
Subject to my lord's permission. In fact, the inquiry has been adjourned at the request of the writ appellant.
That is because the person who has to be examined, her husband
We
died.
will hear.
He made a request.
At the end of motion hearing, please bear in mind the scope of writ appeal, prayer made in writ appeal, and the IA's direction petition, received document, direction petition, fix an early hearing date. Please address on this.
Yes.
Others should not be kept waiting.
Yes,
A senior counsel will take time to wait through all the orders which have been passed earlier. So why to keep everyone waiting? Yes. 1 minute. So we'll take it up after later half. Yes. Now 44. 44. Yes, if councils are present. Appeal. Not there. All right. Pass over now. Pass over at 140. It is being called, therefore pass over. Next case. Yes. 44. You are appearing?
Yes.
No. You are not there. That's why passed over. We thought that it's 145. Therefore, give. What have you challenged in this?
The minor penalty imposed on the judicial officer.
So appeal doesn't lie. Against the order, appeal lies or not?
Appeal lies to the.
Then why?
Appeal lies to the Her Excellency Governor.
Then have you filed an appeal?
Lord, it's a case, my lord.
Have you filed an appeal?
Not in this case.
Then file an appeal.
The major penalty proceedings were initiated and ended up in minor penalty, my lord. 1 year without.
So therefore, no appeal lies.
No, my lord.
You should be thankful that major penalty initiated, minor, you got away with minor thing. So therefore, file an appeal. Why the principle? You are not so young, right, Mr. The principle of availability of an alternative remedy applies to the writ proceeding or not?
Yes, my lord.
Why should you not file an appeal?
My lord. The grounds of challenge were
known.
But the
in this writ petition, the petitioner has asserted the validity of the order dated 25/8/2022, by which a minor penalty of stoppage of one increment without cumulative effect for a period of 1 year has been imposed on the appellant. Paragraph. Appellant who is a judicial officer. Petitioner who is a judicial officer. Paragraph. What is the submission number 1?
The evidence, my lord, the inquiry that was conducted.
Learned counsel for the petitioner submitted that
the charges framed on ground numbers.
Learned counsel for the petitioner has addressed this court on merits of the matter and has pointed out that the imposition of penalty is wholly uncalled for in the facts and circumstances of the case. Paragraph. We have considered the submission made by learned counsel for the petitioner admittedly against the order dated 6/4/2020. Brother tells me that administrative committee of this court has taken a lenient view. Charges have been found to be proved against. This is not a conversation, right? The order is passed 136 SLP. Yes. Yes. Counter filed.
Yes, madam. I'm for the respondent number 2, 6, 10 and 11, madam.
You are filed, no, everyone. Petition is admitted for hearing. Rejoinder, if any, to the reply, if any, to the counter be filed within 4 weeks. Admitted for hearing, right? You right. Then next. This is
Please, your lordship.
3 to H.
46, I appear, my lord. This.
Yes, Mr.
My lord, local status in view of the residents, my lord. Lordship.
Yes, Mr.
Lord,
You appear through video conferencing only. Why you are not here? Yes.
My lord, my lord.
Oh, yes. Yes, please.
Lord, mighty state, my lord, keeps all of us running around here and there.
Yes, please.
My lord, IA3, my lord, I have sought a direction, my lord, to be considered as local candidates, my lord. In view of their residence, my lord, except the study part, MBBS, they have been.
You people have studied in Ukraine, right?
Yes,
Ukraine.
China, my lord, China.
No, what?
Except that, my lord, they're born here, studied, and they're working for the state, and
No.
they'll have to work another 10 years, my lord. That's the bond conditions, my lord. Geo 155. They'll keep working for the state, my lord. They're all recruited as local. That's the reason, my lord. Without going into any other aspect, my lord.
Which IA you are fighting, Mr. Which IA?
IA3, my lord. IA3, my lord.
3. Which is it? Where is it, man?
My lord,
We will hear you at 2:30, Mr. Counsel. We will hear you.
May request tomorrow, my lord.
Why?
My lord. Tomorrow, my lord.
No, it's Friday. We will hear you. It's only 1:50. So we are.
I'm not.
It's already 1. No,
not
no.
in the,
You join, Mr. We will again hear you at 2:30. We'll join.
tomorrow, my lord, if you like, my humble request, my lord. Tomorrow.
Tomorrow is Friday, Mr. You understand, half day.
I'll take a chance, my lord. I'm not in Hyderabad, my lord. That's the reason.
Next week, any day.
Mr. Rao says next week.
Monday, my lord. Monday.
Why, Mr. Acha, you want to argue right away? Argue.
No,
You don't want to.
No, my lord.
No, you don't want. No, Mr. Counsel, you don't want that we should have lunch.
No, my lord.
We will think that we are fasting. Go ahead.
No.
Which is IA number 3?
I'm requesting, my lord. I'm not.
No. But you are not in Russia, right? Or China. Time zone is same. Wherever you are, time is 1:50 only. See what is the time in your watch. Please see the time in your watch.
Yes, my lord. Yes, my lord.
So therefore, by insisting that it should be passed right away, copy should be sent to your location.
My lord, because of my inconvenience, my lord, I'm making a humble request, my lord.
No.
Tomorrow,
You argue. What is IA 3?
Sorry if I have.
No, please go ahead. What is IA 3?
But IA3 is seeking a direction, my lord, to the university to consider the petitioners as local candidates, my lord. My lord, these petitioners, while
No. What is the writ, Mr. What is the writ petition?
writ petition is challenging Geo 73, my lord.
What is 73?
73 is the, my lord, 100% reservation, my lord, amending the
That
rule.
you in your distinct petitions also, like we have passed an order, right?
Yes.
Same 3-2H, no?
Yes, my lord. Parimateria. Yes, my lord.
Perimateria.
Parimateria, my lord.
How can we pass a different order in your Mr. Counsel? You should have been fair enough to say that, sir, you have already passed an order and you have posted the maximum 6.9. So then how you are arguing that I should be treated as local?
My lord, this covers the issue in WP 21268, my lord. At paragraph 8, your lordships held that it is parimateria with my lord, paragraph 41B of the presidential order. They have to be treated on par.
No, Mr.
My lord.
That is a different case. You are not challenging rule 3.3B of the rules. Right? But again, Mr. Again, you are making a reference to the rule which is not under challenge in 3.2H. This all sorts of like misleading submissions are made. We are sorry that.
I'm sorry.
3.3A, in that case, rule 3.3B has been read by. And 3.2H. You are relying on that judgment to say that I should be treated as local candidate. That is the issue.
That under the presidential order, paragraph 41B also is parimateria with rule 3, my lord. That's UG, undergraduate rules, my lord. 2017.
No. In case your challenge is to rule 3.3B, straightway we allow the petition and grant you the relief, which we have granted in
no rule is amended, my lord. In PG admissions, my lord, already presidential order covers, my lord, petitioners like these. Under paragraph 41B.
We'll continue at 2:30.
May I request for tomorrow, my lord, or Monday, my lord, if your lordship, my lord, humble request, my lord.
We don't know whether this order itself you will file SLP saying that I made a request to the division bench instead of Friday fixed it on Monday.
My lord.
Lighter vein, Mr. You have petitioners. You means petitioners have a fundamental right of access to justice. We are lighter vein. What can we say? 1:55. What can we say when you are taking us away from lunch? What can we say? after arguing the matter to some extent, Mr. So and so, Mr. P. Tirumala Rao has appeared through video conferencing. After arguing the matter to some extent, learned counsel for the petitioner prays for adjournment to enable him to address this court on IA number 1 of 23, 2 of 23, 3 of 23. List. No, this is which 45 and 46, right?
Only 46, brother. Only 46.
46, 46. IA so and so. List tomorrow. Date. You take a chance if 1:30 is the bench.
My lord, my lord.
My friend has already challenged me under Article 32 before the Supreme Court, challenging with
That's simply disposed of, dismissed. In fact, with an request the High Court. Petitioners were directed to request the Honorable High Court. In that today it came up, my lord.
It has been dismissed.
Yes, my lord.
Dismissed holding that
petition
he has initiated parallel proceedings. The proceedings are pending before the Honorable Court. In SLP will
these petitioners were not in the proceedings before the Honorable High Court.
Yes, yes. Somebody else will go now to Andhra High Court, Punjab and Haryana High Court also. So they will say. Yes. Okay. It covered by our judgment?
No, it's not covered.
Not covered.
My lord, one of the cases in the covered judgment, my lord, similar facts are there.
24291,
Yes, my lord.
where have you studied?
My lord, first to ninth abroad, my lord. Then 10th, 11th, 12th over here, my lord, in
Yes.
Hyderabad.
So how will you become local?
My lord, he has taken a drop also, my lord, 4 years.
Or no drop, study. Residence
In the light of order,
Yes, my lord.
your prayer clause, Mr. What sort of innovative prayer you make really, we don't understand. See the prayer clause. In those cases, validity of rule 33B was under challenge. You have not challenged it. What can be granted to you?
My lord, I have challenged the GO, my lord. If your lordship may, GO number 114 I have challenged, my lord, in my prayer.
One, read. Action is arbitrary and GO is not challenged. Action is challenged. I don't understand half of each prayer. Please read it for our benefit. Mr. Rao, he has not challenged the rule. He has challenged the action
of the respondent.
Declaring.
You don't like, you don't dictate the prayer. You have not read it and you don't know it. Read, it is prayed.
It is prayed that this honorable court may be pleased to issue an appropriate writ order or direction, more particularly one in the nature of writ of mandamus, declaring action of the respondent. I agree, my lord. Action of the respondent I have used.
No, read further.
In declaring the petitioner as non-local candidate as per QMS 114 dated so and so for admissions into MBBS admission for so and so years under competent authority quota as illegal, arbitrary, unconstitutional and in contravention of the procedure established by law, and set aside the same as illegal, arbitrary, unconstitutional and in violation of articles 14, 19 and 21 of the
So
Constitution.
validity of rule 33B is not challenged. We cannot grant you the relief. This very judgment is against you. That where we have accepted the interpretation of put forth by Mr. Rao that you don't fall in that rule.
Yes. My lord, if your lordship may see the common order, my lord, one of the cases in the common order has
Not
similar
the cases you are referring to, writ petition 22449, where 1 to 11th she studied abroad.
Yes, my lord.
But we have not accepted, said that she is entitled for admission. In the light of the judgment, they will decide whether she will fulfill the requirement or not.
Yes, my lord.
So, if it is not fulfilling the requirement, that's why you don't read the facts of the case. Tell us from the proposition of law.
Nothing, Mr.
My lord, your lordship may come to para 91 of the judgment. My lord.
Please read. We have already held that rule.
We have already held that rule 3, Roman number 3.
No, you have not challenged the validity of the rule in your case.
No, there is a mistake in the prayer, my lord. I agree with your lordship.
Mistake in the prayer.
There is an oversight. in the prayer.
We have not committed the mistake.
My lord, I apologize for the same, my lord.
And we are not seeking admission to BDS course.
I apologize, my lord. I admit, my lord.
Then amend the petition. Instead of seeking lunch motion, amend the petition.
Yes, my lord.
Instead of seeking the lunch motion and troubling us, amend the petition first.
I'll amend.
And develop this habit of reading the petition before they are filed or even before they are argued.
Yes.
You are a young man, that's why we are telling.
Yes.
Learned counsel for the petitioner on going through the prayer clause, prays for adjournment in order to enable him to amend the writ petition. List in the next week.
So local, non-local, your lordship. Petitioner was non-local status. Petitioner was born in Hyderabad. She was studied till 8th year.
But he studied for 4 consecutive years, my lord, in Andhra.
She has
whatever, but then this is he not entitled to the benefit of judgment?
Not only.
You will examine provided he
Your lordship was-
produces a permanent residence certificate.
Your lordship was pleased to read down the your rule small b only on the ground that they are resident.
No.
But in those cases, only 2 years they studied
They
outside.
will not, they will not, see Mr. We haven't not decided who is the permanent resident. That is the issue to be decided by the state. Therefore, we have left it to the discretion of the government if they produce whatever facts he will plead 8th class or 10th class, whatever, and wherever. If the government gives them a certificate competent authority and they produce it before you, you deal.
They can produce only Millard certificate, Millard the 8th class. 9, 10, 11, 12 Millard they studied Millard Andhra Pradesh.
Andhra Pradesh? No, whatever. We are not saying anything. We will say that in terms of that we have passed an order, right? One case.
No case Millard. All the cases which are lots of.
No. We have passed an order. Which that order we had passed to one paragraph order following WP judgment.
In that case, Millard.
Please see this order. We are not saying anything on facts. Please read the order. This is passed in your presence only.
The facts in that case is, Lord, 2 years he studied outside.
No, please read.
Lordship was pleased to direct the respondent to consider in case he files Millard the residency certificate from competent authority for 10 years.
Hey, we don't.
For a period of 1 week. But
the competence, the residence certificate within 1 week, if they file, you will consider. If he doesn't get it, we are not saying. Because we can't enter into.
Well, last people left it open to the registrar of the university.
Please see the order. This is asked in your case only after hearing you. Next part, the operative portion.
For the reasons assigned by us in the aforesaid common order, it is directed that in case the petitioner produces residence certificate issued by the competent authority of the government of Telangana within a period of 1 week from today, before the university shall treat the local. Lordship kindly say, instead of directing to treat, Lordship consider. Lordship say consider. Then it's a positive order.
Give. You seek modification of this order also. Mr. Rao.
Seek modification of this order also.
To the extent of consider.
Again, Mr. As we can see that you will not treat him. Again, we see he is getting another brief standing with lunch motion, and you are saying again arguing Hyderabad he didn't study 10 years.
No, he did not study 10 years here.
Wherever he may have studied. Supposing if the 1 minute. What we are saying, Mr. Rao, instead of examining each case, that whether he studied for 8 years in Telangana or 6 years and then studied wherever, we have said that if competent authority of the government of Telangana will examine all his claim, whether he is a permanent resident or not, and that certificate if the petitioner produces, it will bind you, no or not.
1 minute.
Do you think that they will issue just like that? And also who has studied 1 year and remained in America.
Tahsildar giving Millard as and when we go to the Tahsil office, a residency certificate. Within day, they are giving without any conducting inquiry. The Tahsildar is an authority to do a residency certificate. Millard is a local candidate in Andhra Pradesh. He is a local candidate in Andhra Pradesh. As per the presidential order, he is a local candidate. He wanted to be treated as a local.
You are a local in Andhra, Telangana, Punjab, Haryana, and everywhere, right?
No, I am not. Because by virtue of the reorganization bill, my mother is allocated to, she is a girl child. My mother is allocated to.
1 minute.
Yes, yes.
Are you a local candidate in Andhra?
No, I'm not, Your Lordship.
Not my friend. He says not.
I'm not here nor there, Your Lordship.
As per the presidential order, he studied 4 consecutive academic years, ending with the academic year in a qualifying exam. He studied Andhra Pradesh. That is a not 4 1 year. He falls under 4 1 year presidential order.
Lordship,
You are not a local candidate, Mr. in Andhra. Please tell us.
I'm not. I'm claiming my residential local category from AP Telangana, Your Lordship. I'm born here and brought up here till 8. Due to my mother allocation on the reorganization bill under section.
No, but you can't be treated as local candidate for both these states, Andhra and Telangana.
I'm not claiming my local candidate in AP, Your Lordship. That may be recorded, Your Lordship. I'm
not
claiming my.
Means we are not running any college where we grant admission.
I'm
not. Okay. But we are just trying to examine the submission.
Yes.
Like this thing. How can you be a permanent resident of Telangana and Andhra both?
I'm not, Your Lordship. I'm not claiming the permanent resident from AP, Your Lordship.
There's 16 of the affidavit. We gave the table.
16.
16 Lordship. Affidavit.
Vijayawada.
For
Vijayawada is in Andhra, right?
Yes, sir.
There.
My residence certificate is here, Your page 32, Lordship, may I kindly. The competent authority. Page 32, Lordship, may I.
Let's see the certificate.
Yes, 32, Your Lordship.
One prayer. Direct to consider local candidate. The only prayer is local candidate. Right?
Yes. My father is working in BHL in Hyderabad, Your Lordship.
Would only be confined to the professional who have approached, who are challenged with it. How can they do it? Not going to be incitors, not challenging you, standing to that peer. But believe come to person very often will be confined to person before vote. We do not can usually say
Mr. Srujan, since you have not challenged the rule, how are you entitled for the relief of what is granted in the common order?
My
challenge of one thing which we are broadly discussing is that the declaration of law may be in rem, but relief may be confined to petitioners of that case. Those who had challenged the rule and had approached the court in time. You have taken your chance in Andhra, not getting admitted, then claiming Telangana and not challenging rule.
No. This my submission will be this honorable court has already 3-3. C has been already struck down.
No.
On that basis, I need not to challenge once again the values of the same rule. Is what my submission.
You are wrong. We have not shut down. We have read down.
The benefit of reading down has to be confined to, we can well within our right to confine the benefit of reading down to the persons who have approached the court well within time. And you are sitting on the fence waiting in Andhra, then you are not declared in local area there. Then local candidate, then you shifted.
I have applied that.
No.
In the month, Lordship, may kindly.
1 minute, one thing only. This
23 itself, I have applied for NEET here.
Why have you filed this petition today? Please tell us.
23 itself, I have applied, Your Lordship. I was expecting, but I was I'll be treated in local category. I was shown in the Andhra category, Your Lordship. And the
Andhra Pradesh, you were treating as local expecting.
No. In Telangana, I have applied on 23/8, Your Lordship. On such application, my status has been shown as non-local, Your Lordship, from Telangana. I was treated AU, Your Lordship.
8 days, what were you doing? Watching the proceeding in the court and trying to find out which way the wind blows.
That is not the.
No, explain. 23rd, you applied, you were shown as non-local.
I was waiting for the second round.
When?
Second, 23/8, I was applied for the first round.
No, when were you shown as non-local?
On 23rd itself.
Then what did you do for?
She got 3,300 rank, Your Lordship. In the state
1
category.
minute.
Yes.
8 days, what did you do? Every day's delay in such matter counts. We have held so in Karnataka and that order was assailed in division bench. We did not grant the relief to a person who came 9 days after. And assigning reason, we have rejected the prayer petition order upheld by Supreme Court saying correct that in these matters you have to be extremely vigilant.
Yes, students are under tremendous pressure of the exams and the counseling, your lordship may,
No, there is no
because
exam.
they are going through lot
No
of trauma.
exam.
They don't know where they belong, their status, your lordship, Andhra or Telangana, one brought up here, now they are shut out because by virtue of section 77, because the mother is allotted to AP, your lordship. It's not because of her mistake, your lordship. Lordship may kindly.
No, but this all has been deleted, right? I tell you that we cannot argue in a fresh deleting. Oh, so what is your prayer with the petition, Mr. All this has been examined, and so you are saying that on facts of the case you are a local candidate.
Yes.
So which preceding the rule requires that 4 preceding years you have to study in a local area, and you have to either reside not taking examination, not appearing in the course, or otherwise 7 years consecutive years in an academic year and 7 years you should reside. So tell us 1, 2, which class? First 2.
Yes, GOP here. GOP number, the government, the presidential order.
Facts. Your case, when did you, where from you studied?
Yes, your lord. From 1 to table which I specified is page 7, page 16, your lordship.
Page 16.
First and second class, from 2009 to 11, your lordship. She was born in Telangana in 2004, your lordship, in Hyderabad.
So, Mr. 4 consecutive years you have not studied in state of Telangana.
No.
Correct? Under the rule.
Yes.
4 years you have not stayed in state of Telangana.
Yes.
Therefore, the other clause, 7 years does not arise. You have neither 7 years studied in Telangana, nor 7 years resided in Telangana, nor even 4 years.
2000 till 2000, from 2004 to 2017, she was in Telangana.
Requirement, read.
Yes.
Where is the requirement? Rule. Rules not annexed in the petition.
From 2009 to 17, she studied in Telangana, your lordship. That is till 8 years she studied in Telangana.
Rule. Where is that rule? You are
In first case, rules were
I
fine.
he has not challenged.
First lunch motion, rules were fine.
No, since he has not challenged the rules, therefore he doesn't need to rely on that.
It's not the case.
Where is that rule thing gone?
I've extracted the rule C in my
3 Roman 3, Miller.
Where is the rule?
Capital B.
What this is kept, madam, here. Judgment copy, there the rule is there. Why it is kept here? So that I cannot pick it up, right? Not this one, these.
3 years.
It's a 3. We have noted in the judgment.
Rule 3, B, local candidate. A candidate per admin shall be
Not less than 4 consecutive academic years.
Yes.
All right. Anything else?
My submission is to lordship that Till 8th, she is.
Yes.
My submission will be that till 8th she studied here.
That we have understood.
By under because under the Reorganization Act, mother has allocated to AP, Your Lordship. She being a girl child, left with no other option but for go with the mother, and she has studied her 9th, 10th, and 11th, 12th in the AP, Your Lordship. And subsequently, she returned to the Telangana because his father is working here, and she took her long-term course in Hyderabad, Your Lordship, for 1 year from 21 to 22. 2 years she has studied here only subsequently, Your Lordship. She was taking long-term course for the MBBS, Your Lordship, and she secured 520 marks, Your Lordship. And she has claimed and she has even applied for the residence certificate. The competent authority has issued a residence certificate stating that she is the resident of Hyderabad.
Where is the certificate?
Page 36 here. Page 30. Page 32 here.
It's a bogus certificate.
There may be inquiry with that. I should not.
10 years he studied, 2022. Certificate is given 2022. It says 10 years he studied. 10 years he resided.
It is incorrect. Mr. Seemingly incorrect on the face of it, because your case is that 4 years on account of mother's allocation to state of Andhra. I was studying for 4 years and came back to Telangana after completing.
Yes.
Correct?
Yes.
And the Tehsildar says last 10 years you are residing at the address given in Telangana. So therefore he is correct in saying that it's a certificate which can't be acted upon.
Lordship also consider page 33 also the one of.
No, you showed us residence certificate. What is your answer? What is your answer to this?
There is a break of 4 years is what I admit.
No, Mr. Residence certificate.
She's a permanent resident of Hyderabad is what I meant, Your Lordship. He is resident.
Read last line.
Yes. He is a resident at above said address since last 10 years. It's last.
That is incorrect. On your own showing, you are not residing at that address for 4 years. Otherwise, your all 4 years will be bogus. Either residence certificate is incorrect or your degree 9th, 10th, 11th, 12th are incorrect. Choose between the two. You will choose the later that this genuine I stayed in Andhra. You have stayed on oath. You have stated so on oath.
That I stated on oath that she has studied for 4 years in Andhra.
This is residence certificate is correct, incorrect.
It will be considered below unreserved category. 15%.
Unreserved category.
That is, anyways, I could claim for by not coming to this court also, Your Lordship.
No.
That is there. That option is always there, Your Lordship. Lordship, the only thing of submission is that she is brought up here only by virtue of transfer to allocation to AP. She has been forced to go with her mother because being a girl child, Your Lordship. Otherwise,
sir, it's better to get that an order of consideration of for your this thing we are advising. Otherwise, you ask us to adjudicate your claim. Then we will have to say so many things which may be not be good for you. You will have to necessarily rush to Delhi. If you want to do that way, we will write a note.
It would be showing.
We will have to say something about your drafting skills also.
Achha.
That how have you prayed, what have relief you have prayed. Just you, since you appear to be a reasonable person, how writ of mandamus can be claimed in these circumstances? See, are they under a statutory obligation? Do whether she has a statutory right? What?
It is ultimately she's the backbone. In fact, her
No, no,
education carries
this-
your lordship.
This see writ of this not you, but we are taking this opportunity to tell everyone. I mean, we have come across petitions today, two petitions where we asked the petitioner to read the prayer clause. He said, "Sir, it requires amendment." Half a page relief, reading mandamus declaring inaction. We don't know how mandamus lies for declaration of inaction. God only knows. See, declaring you have at least not challenged the inaction, you have challenged fortunately the action. But how this mandamus lies? Have you pleaded that this is the statutory right of the petitioner to be treated as local candidate? This is the statutory duty on university to comply. Therefore, issue a writ of mandamus. This is the condition precedent. You have read it in college.
Yes.
That existence of a statutory right and corresponding duty on the person against whom writ is sought. Here itself, everything is under dispute. Your this thing, mandamus, your status, residence certificate, everything is shown on your own, showing it is incorrect. And you are claiming
whatever is there before this with the all fairness, your lordship. I don't know.
Correct.
All fairness.
No, only you should have been more this thing cautious in pleading the prayers. That's what we are trying to, in the fond hope that you will improve in future.
Yes.
This is correct. ABC is fine formatter. We appreciate this, but it should contain different reliefs. Mister, think about before drafting. Don't leave it to stenographer that you type the relief.
No, I haven't.
And this is what it is that he or she has been left to the discretion of this person typing the document to claim the relief. This is the result.
Certainly not. Certainly. I may be permitted to amend the prayer, if lordship permits.
Declaring the result, roll number of local candidate. We don't run declaration under Article 226. All this thing, everywhere, this is rampant, Mister, in this court. Everywhere, declaration, mandamus, inaction, action. One person did not challenge, forgot to challenge the rules on the previous case. Forgot to challenge the rules only. Then sought amendment, just arguing before you. See, that we feel very unfortunate for these young people who are relying on you for their future.
Certainly we.
You means councils like you who do not be serious about it. Mister, if please understand with the casualness with which the members at of the bar deal with the cases. Supposing if the doctors become so casual in treating you, what will happen to you? God forbid that you need any treatment, but if they become such a casual and callous,
Lordship may permit me to amend the prayer to that.
after arguing the matter to some extent, learned counsel for the petitioner prays for adjournment to enable him to amend the writ petition. List in the next week. This is the result of lunch motion.
This is as per the format. Page 37.
When was it issued? 21.
It's 13/7/23.
Mr. Rao, what? Hyderabad. It is very important. Immediately problem in Hyderabad. You go to the lecture. So this is the virus. 8 to 2019 to till date. It's the question is difficult. Like the study 3 years. Array, Mr. 3 years you have studied in Dehradun, and that certificate says that you have studied in Rangareddy district. How the you file? No, it's GP for revenue, medical education. That's why you are smiling. Oh, this action has to be taken. No, please tell us, is there any pro forma of issuing residence certificate? No. What is this pro forma? Please tell us, Mr. Seek modification of that order. So we can say that the certificate can be only in this pro forma. It doesn't say 10 years, 2 years, 5 years like there. That's why we have 7 days we have to. We can, Mr. grant you this thing, consider this certificate will be considered, and whatever it is, you know that this is wrong. That's right. So therefore, you will be well advised to produce a residence certificate which is preceded by an inquiry like the manner he is suggesting in 7 days. Correct, Mr. Mr. Rao. Fresh residence certificate preceded by an inquiry. Yes, madam. No, but this order is already to treat. We can't please appreciate our predicament. Orders can't be different. In case he produces, we are saying residence certificate which is preceded by an inquiry.
It's in the inquiry, normally they would be only able to inquire whether a particular person is residing.
We don't know. You are not the Tehsildar.
No, I'm saying.
You don't know what he will do. Let them do it.
The neighbors cannot say that he studied at so and so place for 3 years. No, this is this.
No, Mr. They don't take things further, right? Better to get obtain a fresh certificate, and if you are, we don't know, if you are a resident, to get a fresh certificate. Huh?
Your lordship may say that let there be an inquiry.
No, we will not say inquiry. We will. You have to. Tehsildar has to do inquiry.
Subject to producing the certificate only, that your lordship.
We will, Mr. Rao, we will direct the Tehsildar also to conduct an inquiry and to satisfy. Mr. Additional Advocate General, you were appearing for cement industries yesterday, so appear for Tehsildar today. Lighter here. We remember that you appear for government. That's why we are saying that let Tehsildar conduct an inquiry. Right? You cannot just issue like what we have seen is Mr. Rao has pointed out, Tehsildar is saying living at the address 10 years. Some is saying 2 years. How can this be? Permanent resident is he has to certify that this person is a permanent resident of state of Telangana. He cannot say living at the address 2 years, living at the address 3 years and give a title residence certificate. So will you call Advocate General? Call Advocate General. Call and learn it. I thought that you are additional Advocate General, but I was told you are not. Not attached. You are not additional AG. Neither AG nor additional AG. Revenue Department may not listen to you. Mark the presence with consent of parties matters. You have challenged the validity of Rule 33B.
114, but I confine my relief to
33B. Write the names, Madam. Para 2, Para 3. This court-wide judge so and so has read down the rule. Para up to 4. Paragraph after paragraph 5. For the reasons assigned by us in the aforesaid common order, it is directed that in case that the petitioner shall make a fresh application for grant of residence certificate to the competent authority of the government of Telangana. The
Except intermediate every. From first to 10th, we had studied in common district in Telangana state.
correct.
This covered.
Then Madam, disorder. 21893. This thing certified copy today. Madam, certified copy today.
And production of
Production of that condition is there on production of residence certificate. Yes.
Lordships kindly item
item
2 of the lunch motion.
No, that's over.
No, I am permitted to withdraw file a fresh with a fresh deal. Permitted to withdraw it and
Item 2. Learned counsel for the petitioner seeks leave of this. Again, another lunch motion tomorrow, right?
with a better pleading, I'll satisfy it.
Again, you will trouble us tomorrow with lunch motion.
I will not.
No, lunch motion you will not seek. Learned counsel for the petitioner seeks item 2, seeks leave of the court to withdraw the petition with the liberty to file a fresh writ petition. Line below. Accordingly, the writ petition is dismissed as withdrawn with liberty as aforesaid. Yes. How?
With your permission, my lords.
Yes, madam.
My lords, I'm suffering with high fever, so I couldn't make it to court today. I'm requesting for a short examination.
All right. Learned counsel for the petitioner She is unwell, seeking an adjournment.
Very well.
Learned counsel for the petitioner prays for a short accommodation on the ground that she is unwell. List in the next week. Oh, you are waiting for this case?
Yes.
Not for cement company. Yes.
Lord, I'm appearing for the second respondent Miller. The regulation issued by the second respondent Miller is being challenged.
No counter is filed, what to do? And they don't want to file counter also. Petition is admitted for hearing.
No, I'm for the petitioner, my lord.
Let them file counter.
There is interim order, Miller. There is interim order.
That has to be extended.
Learned counsel for respondents mark his presence. Learned senior counsel, these people. Petition is admitted for hearing. They pray for and are granted 6 weeks time to enable them to file counter. Interim order granted on earlier occasion shall continue.
Yes.
Also coming up for counter. Commission.
Need to file a counter in this matter. 2 weeks.
Hey, what, Mr. State Host of State Finance Commission, the last date you.
It is circulated to the governor and for orders. File has been circulated to the honorable governor for orders.
So, how much time? 2 weeks to do what? 2 weeks to report that this thing, all chairmen and members of State Financial Commission has been. All right. Learned senior counsel for the respondent, Mr. Harendra Prasad, learned senior counsel and special government pleader submits that the decision that the matter see, we have read down rule 33B of the rules, right? And we have directed that Tehsildar should conduct an inquiry, should, in case they produce a residence certificate issued by competent authority of the government, they shall be treated as local candidate. So in 2 cases today we have come across very casual manner Tehsildar without conducting inquiry. One case the document is titled as residence certificate. One case he says that he is residing for 10 years. Whereas the petitioner's own case is, hey, sit down, mister. You should sit between 1:30 to 2:30. Stand up. If you want to stand up between 1:30 to 2:30, you continuously stand up. Don't like this. We are unable to see. This obstructs the proceeding. So once this thing, the document is titled residence certificate. It says petitioner is permanent resident, or petitioner is residing in the state of Telangana for 10 years. The petitioner's own case is that I am studying where Mr. Rao, Vijayawada. And your this thing is saying that he is, so we told them that you have to choose either your certificate at Vijayawada is incorrect or this certificate is some problem. So he chose to withdraw the petition with the liberty to file a fresh petition. Other case, same thing, that he is residing this Mr. What's his name? CAP category. So he argued so many cases under CAP category. So he said the residence certificate, he is residing at this address for 2 years.
Yes.
So what we have done, we have issued a general direction in that bunch.
Yes.
So please ask the Tehsildar to conduct a proper sort of an inquiry and to ensure not to issue in casual manner. He should look into the fact that if the candidate himself is saying that I am studying in 10th and 11th, 11th in Vijayawada, can he say that he is residing here? That's the you alone can do. Please, all collectors and this thing which is to be carried out.
Yes, my lord. I will inform the chief secretary even by answer. Give instructions.
Thank you. Thank you. So
Certainly.
therefore, I mean, it should be proper and genuine, right?
Correct.
So that only the intention object of the order is to grant the benefit to permanent residents of state of Telangana. That should not be frittered away by somebody getting. You tell tehsildars that you are performing an important task.
Correct.
Don't do it casually when it relates to admission to education institutions.
Certainly, my lord. Today itself we will
Thank you.
issue the instruction.
Thank you.
Oblige.
Yes. You see, Mr. This is hearing. Yes.
Yes, your lordship.
For fixing a date of early hearing.
Yes, your lordship.
Which date? What is the matter about? Just in 2 lines, so that we can fix a date.
It is about land acquisition, that.
Compensation has not been paid to you.
No, it is the challenge acquisition itself, your lordship.
Madam, what is the case about? 2 lines without we are only asking you to, this is only for fixing an early date. So we want to know what is the nature.
This honorable court has
1 minute.
They are challenging the in the writ petition, my lord, challenge the passing of the award that has been not considered, and alternative remedy is provided. So the honorable court directed to avail that remedy, and this
That under which provision, madam?
land acquisition under the new act.
2013.
2013, yes.
So they are the remedy of seeking a reference.
Yes, under 64.
64. So
Yes.
instead of seeking a remedy under section 64, he has filed a writ petition. He has been relegated to the alternative remedy under 64, and aggrieved by that, he has filed an appeal. And
Yes.
he expecting that it should be heard. Fine.
But one thing has to be brought to your lordship's kind notice. He has taken the compensation that was not disclosed by him. He received that, and the LAOP is also filed regarding the claim petition that is pending. Notices has been served.
LAOP is what? Land acquisition?
For reference. For reference.
Reference is already filed.
Yes, already been done.
When sought a reference under section 64.
Yes, madam. Yes.
Sought a reference under section 64.
64.
Under 64 when, madam?
2019 itself, he made an application, 27/5/2019.
Application under section 64.
Yes,
Then reference was made when, madam?
that information, my lord, just now I could collect this when I was, only that, my lord, I couldn't get immediately because today the officer was not.
Who will explain to him? Mr. Harendra Prasad, will you help us?
No, I'll get back to your lordships.
Not
Yes.
you, madam. We have got the information.
Yes.
We are asking Mr. Harendra Prasad to go that side and help us. Because see, 1 minute, mister. You have understood, right? This thing is that he had challenged an award passed by the authority under 2013 Act. He has the remedy under section 64 of the Act to seek a reference. So Learned Single just said that you should go there and avail of the remedy. Against that order, he has filed this writ appeal. Now, just now, as you heard that Learned, whatever has told that 27/5/2019, he had made an application under section 64 of 2013 Act, and the matter has been referred to the reference court for adjudication. So we can direct this reference to be adjudicated expeditiously, or if he wants to still argue, we will fix a date. Please tell him.
Yeah,
We will speak to you.
no,
Please listen to him. Then you can speak to us. Please understand what he is trying to tell. Please,
I understood your lordship. What?
please.
Yes. No, I'm challenging the acquisition itself has been undertaken and under the LAP Act. I'm challenging the acquisition itself, Your Lordship. I want my appeal. This honorable court was pleased to admit my writ appeal on the face of it, seeing my water case, Your Lordship. On the face of it, my writ petition was admitted. And it was again posted for final hearing on.
So this is heard on IA number 4 of 2023. Mark the party in person, write her name. Heard on IA number 4 of 2023 and application fixing a date of early hearing. Line below, taking into account the fact that party in person is a senior citizen, comma, IA 4 of 2023 is allowed. Let the appeal be listed for final hearing on 20th September 2023.
Your Lordship, it may reach that. Your Lordship.
You can make an application.
Much obliged.
Mention that day, 20th September.
Much obliged.
Wait, please. This matter was first listed on 8th August.
Why it has come out change of category? Somebody why? Because this is my
On the previous occasion, my lords were pleased to condone the delay and also
yes,
granted
yes. Fine. So who appears?
I am a respondent, number 1.
You want to file any reply to IA?
I not filed.
Not necessary.
Last 2 occasions, it was adjourned, enabling him to file a counter, but so far they have not chosen to.
He doesn't want to file.
He doesn't want to.
All right. So appeal is admitted for hearing interim order since Laureate Council for respondent number 1 has expressed that he doesn't want to file any counter to IA. IA.
IA 4.
4 of 23. The interim order is made absolute. Yes.
That interim order, I submit one thing. I am appearing.
Everything law remains the same for the government. The appeal has been admitted for hearing. If you want final hearing, make a prayer application. We will consider. You can file. He did not want to file the counter. You didn't say anything that I want time to file counter. We have absolute.
Before learned single judge, we have test ballot. We have already filed counter before learned single judge. Very
Vacate the interim order. That is what my lord said.
So, madam, don't say absolute until further orders. Shall continue until further orders. Whosoever wants to file, he doesn't want to file. If you want to file, fine.
For the reason best known to him, he doesn't want to pursue the matter. But the ultimate victim is the CS authorities. Ultimate
victim is state government.
Sixth respondent. I am appearing for sixth respondent.
Sixth respondent is state government.
No, my lord. It's cooperative society, my lord. Cooperative society.
Victim is cooperative. We will hear. Please file. We thought that you appear for a state government only.
I have to appear for in this matter. I am also instructed by state government.
Marcus possesses
Much of fraud has taken place in this matter. I come up with counter and vacate.
Not counter, vacating.
Vacate.
There is an appeal, no counter.
But I will.
You have already filed counter.
I will come up with it. Vacate.
May please, your lordship. In this matter, I request for adjournment, your lordship. Your lordship may kindly. Lordship, matter pertaining to non-agency people occupying the agency lands, your lordship. In this matter, senior counsel have been engaged.
No, this is 2007 matter.
I completely understand. There is
no question of. We don't want you to understand, not to understand.
The lordship may fix any date for final hearing.
This is for hearing only. We had heard you.
Right? May I submit one thing in this matter?
No, nothing submit.
We are handicapped with bundle, your lordship. That is the reason I am asking for that.
This is the bundle.
Your lordship may kindly give us short date, your lordship. We'll prepare and we'll come.
13 and 3, 16 years. Somebody sitting inside us says, don't grant adjournment. Somebody, I don't know who is that person. But somebody inside us says, don't grant adjournment 16-year-old matter. Don't be cruel to litigant.
My sincere apologies, Your Lordship.
No. Somebody tells us, don't be cruel to litigant and don't this thing accede to the request for grant of adjournment. Because you treat adjournment as fundamental right, that is subject to reasonable restriction. So reasonable restriction is that 2007 matter.
All Your Lordships are please. Next week, any day, if Your Lordships are please.
Why next week? You know next week it will not reach. It may not reach.
Your Lordship may. Your Lordship.
Why? Please argue.
Lordship.
No adjournment. Or you go away. We will deal with it. Our case. We will deal with it the way we want. Because see, eventually, even if you don't argue, we have to do justice because we have taken oath to do justice.
Your Lordship.
You have not taken any oath to do justice.
Instructed to,
right?
I am instructed to request Your Lordship.
To take oath.
Requested to request Your Lordship.
No, nobody instructs, and those instructions are not binding on us. You must understand. Whosoever has given instruction is not here, and those instructions do not bind us. Thank you. Yes. Not agents in the weekly. Active 1970. Where no transaction should be, which should be anything only with the practice of practice. Agency loss.
But we have filed our counter.
We
have filed our counter, Millet.
Please, yes, what you have.
Millet, the only issue, Millet, that has.
He doesn't want to say.
This is a public interest litigation, Millet, by.
Public interest?
Yes.
No, not public interest.
It's a public interest, Millet. In those days, it was used to be numbered as restriction only.
Then you can't seek an adjournment.
Para 3 of the
You will
affidavit.
tell us that it's a public interest litigation. Sit down. Sheila Barse. Sheila Barse. Thank you. Agency loss. You cannot make any grievance also, and you have no locus also. Because this land, agency land, does not belong to you. Does it belong to you? Sit down. Yes. This is public interest litigation. Nothing. 62 years. Public interest litigation.
Para 3, Millet.
Sit down. No locus to seek adjournment in public interest litigation. We can appoint anybody as amicus and proceed to decide. Thank you. Thank you for bringing the cause to the notice of the court. It is our now, this thing, we have to deal with it in accordance with it. Thank you.
I apologize from my side, Your Lordship. I am unable to assist you now.
Thank you. Sit down. Please sit. Don't stand. Why should you stand?
Mr. Sanjeev, under the regulation 1 of
1970.
Even after that, the lands are being transferred.
Yes, Millet. What are the steps that have been taken, Millet, by the government? There is a complaint that government inaction is there in the matter. Millet, I have explained, Millet, at page counter, Millet, para 6 onwards, Millet.
Counters. Counter affidavit of R1, R4, R8.
Millet, this was by R23528. Para 7 minute.
So what you say that these are the
Page 5 minute.
action priorities. Have you seen para 12 of the rate petition?
Para 2.
Huh? Para 12, it has been enumerated that what are the action which is required to be taken.
Yes. Action priorities have been mentioned.
So what are the prayers, Mr. in the petition? You probably cannot contest this prayer. You have to comply.
Yes.
Page 28.
Yes. He is asking Millet and forthwith submit action taken report. Pursuant to the report submitted by the land committee constituted. That I have explained Millet in the counter. That
No. Where is the action taken report when it has been submitted? When? Geo in pursuance of Geo dated 13/12/2004.
Millet, the report was submitted, Millet, by the committee at page 4 of the counter, Millet, I have stated. On 17/11/2006, Millet. 17/11/2006, Millet. Para 6 of the counter.
In the light of Geo dated, Mr. Don't argue for your client. You are an officer of the court assisting the court, right?
Yes, Millet.
And if you don't, even if you don't tell, we will find it out.
No.
So is it, that's why we are telling you this is a public interest litigation not to be contested.
Yes, yes.
So have you done it? Prayer that this thing action taken report submitted, compliance, showing compliance with.
On 17/11/2006, Millet, report was submitted.
The report is dated
17/11/2006, Millet.
Same day it was submitted.
No, pursuant to Millet, the GO 1091 dated 23/12.
When was it submitted?
It was submitted on 17/11/2006, Millet. The committee has submitted a report on 17/11/2006, Millet.
When it has been submitted to us before this court, not filed.
No, before this honorable court, Millet, it is not filed. It was filed before the government, went to the GO, and that report, Millet, has been accepted and action has been taken.
What action?
Millet, the committee has made one.
So before the government and government has taken action.
Yes, Millet.
And what is the another relief? Action taken report under 339(2) tribal areas in so and so. What about this 31, para 31?
Para 31.
You are asking us as if.
No, Millet, para 31. I'm only, Millet, referring to my counter. The
Mr. We reliefs claimed in the petition.
Yes, Millet. Para 29, Millet, is the writ of mandamus.
For inaction.
Yes.
Which does not read, does not lie. Inaction, writ of mandamus does not lie, correct?
Yes.
Then 30. Just now you have told us.
30, Millet, is submit action taken report pursuant to GO 277 dated 1/12/2004. and GOMS number 1091 dated 23/12/2004. He is referring to both.
You go through, Mr. Para 29 to 33 and then tell us what have you done.
Very well. But in fact, there is a report which is already on record.
Please go through it and
Yes.
then tell us what have you done.
I'll go through it. I'll assist you.
Go through means just now. Go through means when.
But page 127, Milad, if your lordship could kindly see, Milad, this is the report pursuant to even para 30. Both the GOs are mentioned here. Page 127.
You tell us, Mr. As an officer of the court, have you taken requisite action or it is still required to be done?
Milad, the counter that was filed in 2010 says, Milad, it is in partial Milad implementation, Milad, as on that date.
Then
Milad, I'll file, Milad, an additional affidavit, Milad, what exactly the today's status. Because counter, Milad, which is on
in
record.
this, Madam, right, in this public interest litigation, the petitioner has prayed for following reliefs. Quote para 29 to 33 paragraph. Learned additional government advocate fairly submits that the action taken report was filed that
Petitioner, my lord. I understand, my lord, that the respondent has to file.
how this has come up 2022 hearing.
So far as the
Records.
Lordship may grant some time for filing a counterwards, but insofar as the issues which have been raised, but several modules have been now there, the Dharani portal.
Mr. Harinder Prasad learned so and so praise fund is granted 4 weeks time to enable him to file counter. 53. 6 weeks time. Yes. Yes. There is no passover, madam. No, passover, madam. 3 process are passed over. Call password. Call password. 25. None appears for the petitioner even when matter is called in second round. Called in second round. What were you saying?
This is now he says that it's not valid and only section 11(6) only arbitrated need to be appointed by High Court or something. Yeah, but he's not registering this with file because there is a the button the court said and there is an arbitration agreement, you have to go to make arbitration. And he's challenging the arbitration 11(6) only, I cannot go further. Nominated arbiter.
It appears that the petitioner is not interested in prosecuting the writ petition. The same is therefore dismissed for want of prosecution.
His objection, the office has sustained the
Office of objection is sustained and petition is dismissed for want of prosecution. Next. Same order.
This is 9(4) CCA rules.
None, same order. So, like against the, yes, madam, none appears so and so against the order impugned in this appeal. In the writ petition, comma, an appeal lies. Appeal lies under. Appeal lies line below. It will be open for the petitioner to take recourse to the remedy of appeal. Then at the appeal lies delete. It appears not interested in prosecuting the petition, dismissed for want of prosecution. Yes, next. Delete. It's always open. Yes. Ah. Yes. Yes, Mr. Yes. Mr. Prabhakar. Yes.
Sorry.
No, no, it's all right. Yes, Paul. Yes, please.
In fact, my lord, what I was requesting was in one of the memos, we said, just, my lord, I will not trouble the court with all that history right now. We said my husband was made as a witness at my request. He has since expired just before the COVID. So now the other day we received notices that he should appear for giving a statement. We gave a letter to the inquiry officer and also to the chief secretary stating that my husband has expired. I am now 85 years. I will also appear and my son will appear instead. So that requires a small modification on their part. I requested Advocate General to issue appropriate instructions to that effect.
You want the petitioner's son to be examined?
Petitioner and petitioner's son, because formally she must also go. Otherwise, there should not be any difficulty for that.
My lord, your lordship, that can
we'll say so that petitioner and her son will.
Petitioner need to be examined, my lord, because she is the
8-9 on that day. You examine her son also.
My lords, so I am appearing for the district collector, permission of the honorable court in its individual capacity.
That's it. First of all, senior counsel. Yes, Mr. Prabhakar. What is?
This is one request. The other request was that I have pointed out the orders of the honorable court where the Advocate General said he will look into the charge memo, whether it requires a remodification.
Where is that order?
That order, I filed it along with the
memo, madam. Memo. We had seen that. No, you had showed us some extract, right?
Yes.
Where is it? No, this is not brief note, madam. Synopsis. What have you, yesterday he filed a memo something.
Yes, ma'am. But yesterday's memo at page 2, memo dated 24/8/2023. I am referring to the orders dated 1/10/2019.
Madam, this all brief note.
Memo on behalf of
memo is filed.
copy, sir.
She's giving
Just
brief
morning,
notes.
morning interview. It's an A4 paper. No, not that one. Morning we had passed. 24/8/2023.
Invariably put a flags.
Page 2, madam. The last paragraph. The Honorable High Court in WA 656 of 17 and batch wide order dated 1/10/19 recorded as follows. Learned AG would inform this court that names of the witnesses to be examined.
This is previous writ appeal, right?
The-
WA 656 is previous one. This appeal.
Which is pending before this court. It's a part.
This appeal.
Yes, this is written.
Previous order.
Yes.
110.
Learned AG would inform this court that names of the witnesses to be examined in the course of disciplinary proceedings has now been finalized. He placed the list of witnesses before this court.
That he will consider. We had agreed that he will look into that.
No, there is one more aspect about the charge gun also. He said he'll look into it. But I would be satisfied if the Learned AG bestows personal attention, looks into this. He'll also require a relook in terms of survey numbers.
This order binds this AG also.
My lords, your lordship's order, my lord, the learned single judge's order is very clear. In the entire exercise done by the then collector will be certainly be examined by the disciplinary authority, my lords. Now, my friend need not have any apprehension in the matter as to how something will be missed. My lords, in compliance of the order, the entire thing has to be, my lord, is subjected to the disciplinary inquiry.
Usual course, in the usual course, I would not have. But the reason is, your lordship will see, repeatedly this honorable court has been pointing out, there is a reason behind this. And in the writ appeal interim order also, your lordship will see, this honorable court while passing, rejecting their application for stay.
Then if anything in violation, file contempt, you are free. Who prevents?
It's not like that. Yes, they will say, but the reason is this not. I want this order to be complied. This is dated, they will look into the.
No, if it is not complied, file contempt.
Yes.
What we can, all we can do is pass an order.
Your lordship would say,
There is already an order, right?
he is my leader. He is my leader. Your lordship is.
No, we have already told senior counsel that he will look into it in previous. This thing, before lunch break only, we told you that he will look into it. He has not opposed that prayer.
Not even my friend is not making it very consciously. If he looks into this 99 and 110, I am happy.
My lords, whatever is put by this honorable court and what is necessary in the matter of the disciplinary inquiry will be certainly met, my lords. Otherwise,
you look into this statement made before this court by your predecessor will bind you also, right?
In fact, I only
1/10/2019. Please look into the requirement of framing of charge.
Yes, my lords. Yes.
And this thing. This need not be said. Examine entire record. The presumption is he will examine. At this juncture, we don't have any reason to disbelieve that he will not examine. So that part may not be correct. But this is an apprehension. But this part you see necessity to reframe the charges.
My lords, the basic charge.
Other thing is that you examine the petitioner as well as her son on whatever 8/9.
My lords.
Right.
On 8th, my lord, let them be present before the authority.
We will.
By then, reframing charges also, let my friend have a look at it.
My lords, that is for the disciplinary authority. My lords, will not insist.
I'm afraid. Problem here.
What is to be into disciplinary inquiry? They'll be free to say whatever they wish to say.
I just looked into that legal provision. But what happens is under the service rules, the enquiry officer cannot now reframe the charges. The charges would have to be reframed by the appointing authority. Now that's where I think my learned friend's advice is required. Otherwise, enquiry officer today when I go on 8th, he won't be able to do it. He will say my hands are tied.
See, he is saying that he will
I'm in a situation.
No, there is no reason to believe at this point of time that learned advocate general is not advised competent. He is saying that it's He is like the statement binds him, right? His predecessor's statement binds him. He is not wriggling out of it that I was not there and all.
No, Mr. But why I am saying that in a lighter vein, my friend is repeatedly saying that the officers will look into it. I am sure officers will not look into it. My friend will have to look
No. See, Mr. Prabhakar, you will come to know only when you permit us to dictate the order. Otherwise, 4:30 and then adjourn.
I'm my only, and so far the criminal part is concerned, for the time being, as your lordships have observed, we will defer it for some time.
In compliance of the order dated. No. This court, after hearing the parties, had passed an order on 18/8/2023. Paragraph. Mr. B.S. Prasad, Learned Advocate General, after obtaining instructions, on instructions, not after, on instructions, submit that 4 witnesses in the departmental inquiry have already been examined and the petitioner shall be examined in the departmental inquiry on 8/9/2023, and an endeavor will be made to conclude the departmental inquiry on or before inquiry within outer limit of 6 CC part should be left for now.
But since 2019, it is still coming up summon stage. I'll be deferring for this time being.
No, but next date we will speed up this thing. That has to be done, right? Criminal case.
For that purpose, if your lordship fixes some date so that this
Then
part.
why we don't want like you to again argue the whole thing.
No, I will not argue on this. Service part will not argue.
No, we'll do it today itself. Why to waste another day? Yes.
What is disturbing is
second, this thing, paragraph, at this stage, learned senior counsel for the petitioner submits that complaint made by the joint collector, right? Complaint made by the Tehsildar is pending CC number 11388/1999 before the 12th additional Chief Metropolitan Magistrate.
Yes.
It is further submitted that in the aforesaid proceeding, till today, summons have not been served.
On accused number 3, 1 and 2.
On accused number 3, full stop. Learned senior counsel has placed the order sheet of the proceedings as referred to the order sheet of the proceedings from 29/11/2009 till 10/7/2023. Paragraph. The 12th additional Chief Metropolitan Magistrate is therefore directed to ensure that summons are served on respondent number 3.
Accused. Accused number 3.
Accused number 3 in the said CC and the and is further directed to proceed expeditiously with the disposal of CC number 11388/2019.
But there is one.
This is, you rightly said, is an eye opener. Thank you. Thank you.
That's what the reason, that's what is part 1.
Oh.
It was 2 people have passed away.
No, is it 113